Oh, sorry. Number one. Contribution of self.
Good morning, Your Honors. May I proceed?
Yes.
Yeah. Your Honor, this is a writ petition filed under Article 226 in the matter of, in the nature of a public interest litigation concerning the valuable rights which has been infringed by the state of AP, particularly in Likavali town, Lower Siang district. Your Honor, this petition particularly concerns two issues arising from one condition. One condition, that is the dilapidated road condition, and not merely dilapidated road condition, Your Honors. This is fatal. The road is such dilapidated, in such to such extent dilapidated that on a monsoon day, Your Honors, when the potholes gets filled with massive waterlogging, we do not know how deep the pothole is, and because of which several unreported cases of cars flipping and students drowning in the water have arise in the Likavali, Your Honor. And when there is a sunny day, the same, although the issue of waterlogging goes away, but then the same dilapidated road makes the environment toxic to even breathe, Your Honor. And Your Honor, this petition is, today this petition is reached as a measure of failing all our efforts to reach the state, Your Honors. Before this petition, we have issued legal notice also, Your Honor, to the state of AP and the particular HODs in the department, Your Honor. This petition this litigation would have completely avoided even if the work could not have been done, but at least one humble reply would have been granted to the citizens, Your Honor. Today, this petition have come here, Your Honor. Not today, our secondary issue is the dilapidated condition, but primarily it concerns our life and liberty, Your Honor, which is beautifully answered in Article 21, Part 3 of our Indian Constitution. So we pray, Your Honor, may this court be humbly pleased to, graciously pleased to issue notice to the state, so that at least we get the opportunity to hear from them what they have to offer us, Your Honors.
State, who is referring? State.
Yes. My lord, as the stage, my lord, notice may be issued. I'll be representing respondent number 1, 2, 3, 4, and 8 and 9, my lord.
No, this is only for a road condition. One road is there for that. It's a very dilapidated condition as per
My
the
lord.
condition. So is there any plan or anything in regards to for that road, for improvement of road?
My lord, for that, your lordship has to issue the notice to the respondent, my lord, so that we can come up. My lord, these are the self photograph, my lord. We don't know how authentic is this.
Same photograph means?
My lord, if you lordship see the photograph, my lord.
I have seen, yes.
Yes, my lord. No one identified this is the original one, my lord. It's a self photograph annexed by the petitioners, my lord. We don't know if this is real or not. This could be fake also, my lord. I'm not saying it's a fake, could be. So at this stage, your lordship may issue a notice, my lord.
So you are representing?
I'm representing respondent number 1, 2, 4, 8, and 9, my lord.
1, 2,
1 to 4, 8
1,
and 9.
4, 8 and 9.
1, 2, 3, 4, 8 and 9. Yes.
And for 6 and 7.
1, 2, 3, 4, 8 and 9. You are for 6 and 7.
Yes.
So 6 and 7 is basically the department concern.
RW.
So take instructions. What is the position now? You are Mr.
Marge Lombi, Your Lordship, Marge Lombi.
Mr. Returned counsel for the petition. And also heard Mr. Eviction. For the respondent. Additional AG for the respondent number 1, 2, 3, 4, 8 and 9.
Yes.
And Mr.
G. Tarak.
G. Tadar, the counsel for the respondent number 6 and 7. Standing counsel for the respondent number 6 and 7 for the department. no formal notice is required to be furnished as they have already received the notice. However, a copy of the petitions be furnished to the respondent side. This is an petition filed under 226 of the Constitution of India for the seeking relief against two particular issues prevailing on the village roads and a portion of the national highway within Likavali town. Mr. Itara submitted that he will take instructions from the department concerned as to whether there is any the department concerned in this regard. Next. The demand will be accordingly listed. When you can be listed? You take instructions from the department.
One is of highway and
Yes.
others, in case of RWD, it must be some rural link roads. So which specific? We didn't. No, look.
My lord, the university is to issue notice to respondent file, my lord. I don't know.
Oh, 5 is there, na?
Yes, 5 is a
Okay,
highway,
issue notice
whether it's
5.
highway or it's a rural link road. If it is a rural link road, madam, the RWD is.
Okay. Issue
If it is
notice.
highway, then it's a.
You know, we're fixing it returnable within 4 weeks.
My lord.
Returnable within 4 weeks. We're issuing notice. Let us.
Thank you so very much, Your Honor. This is not a mere notice for us, but envelope of rescue and remedy, Your Honor. Thank you so much.
I don't kindly direct the respondent to take requisite copy, madam, certificate. Requisite copy, madam.
No, yes, copies.
Yeah, copies,
You furnish the copies.
requisite copy.
Requisite copies. Copies. Copies.
Marvelous, my lord, the case before the lordship is here. I am challenging the recruitment rule, which was framed in the years 2014. In this case, I am serving as a treasurer in the feeder post of the Draftsman. So in due course of the time, there is a existing recruitment rule for the Draftsman, wherein there is a provision of the promotion from the feeder post. Since I am serving in the feeder post, I am waiting for the next opportunity to get promotion in that is called Draftsman. Now the new recruitment rule, as per new recruitment rule, there is no provision of the promotion. All should be on the basis of the competitive examination. Therefore, I will take the lordship to the page number 48. This is type out copy, wherein I am putting in challenge before this honorable court.
Yes, number 26.
46, 40, now 48, main portion in it, 48.
Yes.
My lord, may kindly see the column 10.
Hmm.
The method of the recruitment, whether by the direct recruitment or the promotion or by the deputation, absorption, and the percentage of the vacancies to be filled up by the various method has been shown, my lord. 100% by the direct recruitment from the select list prepared on the basis of the written competitive examination followed by the Vababos test as prescribed by the office memorandum number such and such. This office memorandum, my lord, talking about only the fresh recruitment. Therefore, my lord, now in order to hold the post of the draftsman, my lord, one should participate in the, my lord, 100% recruitment. So I am agree against this, my lord, recruitment rule. Since, my lord, the previous recruitment rule, my lord, may kindly
Why the word is there, the method of recruitment, whether by direct recruitment or by promotion? Why the word promotion is there?
my lord,
If 100% recruitment will have to be but through competitive exam,
my lord.
then why the provision is there, still there is the direct recruitment or by promotion?
Because my lord, I am already in the my lord, service since 2010. So only the way, my lord, there is a provision of the promotion. Now the possibility of the promotion to the next higher post has been taken away by these recruitment rules. Meaning, my lord, despite of serving in this feeder post in the many ticket also, there is no chance for me to the promotion, man. So, my lord, that this is just let the notice be issued.
It's going to appear, this additional. AG will appear or AG will appear.
Notice has to issue to the AG. I am appearing for 1, 2, 4, and 5.
1, 2, 4 and 5.
3 administrative reform. Administrative reform.
Hard Mr. C. Modi, the Honorable Counsel for the petition. It's an application under Article 226 of the Constitution of India. Challenging the recruitment rules by notification number AR 02 of 2014, dated 5/8/2014. So called the recruitment rules to the post of Draftsman is grade 3, passed by the Arunachal Pradesh government, Department of Administrative Reform, Civil Secretariat. Yes. Issue notice to the respondents. Registered AD. However, Mr. T. Dunn, yes, they already appeared for the respond number 1, 2, 4 and 5, no? 1, 2,
1, 2, 4, and 5.
1, 2, 4 and 5. And you are appearing for?
3. Why did I?
Why did has appeared for the respond number
3.
3. Also issue notice to the learned
6 to 11 notices.
and other respondents. No formal notice is required to issue on respondent number 1, 2, 3, 4 and 5. 1, 2, 3, 4 and 5. No? However, the requisite copies may be served to the respondent side. List the matter accordingly after 4 weeks.
Extra copy.
Extra copy, I have already passed the order. Copy, forensic copy to the other. Please start.
Lordship, notice to respondent number 2 is still awaited.
Is already been admitted here or not?
It's admitted, your lordship.
Admitted.
Yes,
Already
admitted for here. Yes, your lordship.
Notice was also issued, I think. No?
Yes, your lordship. Notice issued and service report awaited in respect to respondent number 2. It's a POXO matter.
Notice has to go. I is for suspension of sentence.
Yes.
Hard Mr. Chitalu, the learned counsel for the appellant, and also hard Mr. E.J., the learned additional PP, appearing on behalf of state respondent. The service on respondent number 2 is still awaited. You have taken steps on 211, so it can be awaited for another service may be awaited for 2 weeks.
2 weeks. Lordship.
More 2 weeks.
Yes.
Thereafter, if it not, what was the process of taking steps, in fact? In what process we have taken steps?
It has
Because
to
nowadays
be,
after
it has to be routed
we
through
go-
office of PP, your lordship.
Yes, it should be routed through
Yes.
the, whether it has been,
Yes, it has been, your lordship, perhaps they have no serve as the copy. They have to take steps to registry and registry will furnish as the copy.
that's why I'm
Yes.
asking on what, in which method you are taking steps.
Lordship, that I have
It
been.
has to go through registry, through public prosecutor, office of the public prosecutor. Have you taken steps in that manner?
Okay, Lordship will serve the copy to the self.
He may not be aware of it, your lordship. He is appearing on behalf of the council.
The court issue fresh notice on the respond number 2 as per of the direction, as per notification through office of the registry, through public prosecutor and through office of the registry and the public prosecutor. Come on. If not already taken. However, the step may also be awaited for the service may also be awaited for the respondent. List the matter accordingly after 4 weeks.
Lordship, 2 weeks.
For record, we have received the record. Can-
Record, your lordship, perhaps it has been called for, but perhaps it has.
Record, call for the records is there, but not received. Received. Record has already closed. LC has already been received.
Lordship, this may be list after 2 weeks, Lordship.
2 weeks.
Yes.
2 weeks, if it is possible, then we give you 2 weeks. After 2 weeks?
Yes.
List after 2 weeks. Okay.
Obliged.
Item number 4, may it please the lordships. Well, I am appearing virtually in the matter for the appellant. Well, although this matter has come up for orders today,
Oh, this
Uh,
is,
am I audible, Malaz?
yes.
Well, although this matter has come up for orders today, but this can be disposed of if the respondents' counsels are agreeable to it.
Interim is already disposed of. I
No, it
has
has not
already
been
been
dis-
disposed of.
The IA is pending. The IA is for stay, Malaz. But at present, I am not pressing that IA.
Okay.
Mayor, please. Pause. My lord, I am appearing on behalf of respondent number 1, my lord.
Yes.
Writ petition. I may be granted some time to file my affidavit in opposition, my lord.
You are for 1.
Yes, my lord.
So 2, 3, and 4, they have already filed their affidavit.
Yes,
Uh,
2, 3, and 4 have filed, Malaz. We have received the copy.
Regarding,
Yes,
They have filed, Malaz. The state has filed.
only 1 is left, no?
Yes.
And 5, what about 5? 5 is also represented by whom?
I think my lord, 5 is 2, 3, 4 has been filed, my lord. Hmm.
11, 9 order.
Yes, my lord.
Hard, Mr.
F. Vishwakarma, Malaz.
Hard, Mr. At A.
S. Vishwakarma.
As B. Sharma, the learned counsel for the petition, and it's appellate, no? Yes.
And for the appellant, Malaz.
Yes, and also heard Mr.
H. Lampu, my lord.
H. Lampu, the counsel, appearing for the respondent number 1. And Mr. R. Rattan, the learned. 2 to 5. Additional, he's also additional.
Yes.
Additional is for respondent number 2, 3, and 4.
2 to 5.
2 to 5 also.
Yes.
2 to 5. It is submitted by Mr. Renzo, the learned counsel appearing for the respondent number 1, that time will be that some more seeking sought for time, some more time to file their written affidavit in opposition. However, from record, it is seen that respondent number 2, 3, 4, and 5 have already filed their affidavit in opposition. How many weeks you need?
3 weeks, my lord.
3 weeks. list the matter after 3 weeks. And
Plus,
the
can a date be
respondent
fixed?
number 1 is hereby directed to file his affidavit of position within the period in honor before the next date of listing. Yes?
Can a date be
Yes,
fixed?
Mr.
now?
Sharma? Date.
Can a date be fixed now?
Okay. 27/11 will do? After
Yes,
3
Lords,
weeks?
it will do, Lords.
Okay, we're fixing it at 27/11.
Oblige, Lords.
27/11. Whether there is a claim or not. Yes, what about the IA, this one?
Lordship,
It's a condemnation. So it was, delay was 290 days.
No. My lord, delay is 1 day.
Huh? 1 day.
Lordship, this may be taken up tomorrow since leading counsel Jitalo is unable to attend today, this may be taken up tomorrow.
Who is the council? Conducting council?
Jitalo, that leading counsel.
Jitalo.
Yes. Due to some personal issue, he is unable to.
See, if the, yes, do you have any objection
For delay, your lordship.
for delay?
No objection. Your Lordship.
Yeah, don't have any objection. Okay. We can dispose of the matter because the state has no objection.
IA को dispose करना.
He is confused.
IA may be
Okay.
dispose of, your lordship.
Yes, we want to dispose it. So you are Mr.
Yes, Irang, on behalf of Jitalo, Lordship.
S. Iram.
Yeah.
On
Irang.
behalf of Jital.
Yes.
So and so. And also had Mr. E. Etted done an additional PP appearing on behalf of state respondent. This is an application under Section 5 of the Limitation Act for condoning the delay of 290 days in preferring the connected appeal against the judgment and order dated 13/11/2023, passed by learned session Judge Bomdila, West Coming, in session case number 12 of 2023 under Section 302 IPC, convicting the accused appellant under Section 302 IPC and sentencing to undergo life imprisonment along with a fine of rupees 20,000 in default aside for 3 months. It is submitted by Mr. Iram that the delay was where you have you seen these?
No,
petition?
I don't have the
345 days, your lordship.
Huh?
Delay. Your
Here
lordship.
here it is calculated as a 290 days.
9. Your lordship will find in the cost title itself, your lordship, and the prayer portion. Page number 6 of the IA, your lordship.
I don't know, it is handwritten, but 290 days is there.
Here in my, your lordship, it's written 345 days.
345 days. So we have not collected the copy. It just should not be. If you have any correction or suppose, then the correction should be there also in their copy. Let it be done.
Yes, it's difficult. The number
Yes.
in our IA, it's 345, your lordship.
345
Yes.
days. Then if it has a 290 days, huh? 290 days.
290 days.
290
Corrected
days.
one.
Of the corrected one, handwritten correction. Though handwritten correction is not allowed nowadays, but it has been corrected, the handwritten correction is there.
It is also handwritten, your lordship.
This is also handwritten.
Yes, your lordship.
Then he has no idea, I think.
In that case, let them correct it first, your lordship.
Oh, yes. But while passing the order, it has come to the notice as pointed out by Mr. Ete that the copy which was provided to the the respondent, the delay is mentioned as 345 days. But in the present petition itself, it is written as 290 days. However, it is handwritten, and one correction is also there. Accordingly, the appellant is hereby directed to file the corrected and oblique amended copy of the I, and also ask to serve the proper and selected copy to the state respondent side. Let the matter be listed after 3 weeks. We are supposed to dispose of the matter, but why you have filed these things? Here for copy it is for
We will list
345
day
days.
after tomorrow. No, sir.
Huh?
Day after tomorrow. We'll correct it.
No, you made the correction and all on the day after tomorrow.
Yes.
May not be possible also. Then after 2 weeks?
Yes,
After
sir.
2 weeks, list after 2 weeks. Make correction and corrected and amended copy, file the or amended copy of the IA, then the matter will be hard. What could have been disposed of today itself.
Yes. Obliged.
Yes.
My lord, I is for the consideration of delay.
Okay. How many
Uh,
days?
1 day technically, excluding Saturday.
Saturday, Sunday, including only 1 day.
Yeah, including Sunday, Saturday is 3 days. Technically, it's only 1 day, Monday.
Yes. Ms. Sangeeta,
Yes, your lordship.
you have any of the,
I have no objection. I have.
you are representing
1 and 2 in
1 and 2. I think for the 3 days, the others don't have any objection.
sorry, your lordship. 1, 2.
1, 2,
Yes, 1, 2 and
only 1 and 2.
yes, 1 and 2.
But formalities has to be there. Otherwise, it's okay. But issuing notice is a formality. There are, I mean,
My lord,
6,
this is only technically only 1 day, so
No,
that
I have
maybe
understood. 7
and,
numbers of respondents are there. So, private respondents are also there. So we have to observe the formalities. Otherwise, I don't have any objection. She also don't have any objection. 2 or 3 days, it's okay. But for formality's sake, we have to issue notice. Okay. Heard Mr. Swain, so we can counsel for the petition. And also heard Ms. Sangeeta, the learned senior government advocate, is representing respondent. Issue notice to the other respondents, including the private respondents. No formal notice is required to be served on number 1. However, requisite, but I'll be getting listed matter. When it can be listed then? Notice has to go.
Yes, up 2 weeks.
2 weeks.
Within 3 weeks.
2 weeks also.
3 weeks,
3 weeks also.
just after 3 weeks.
Obliged.
Most obliged.
May I please, madam?
Yeah.
Under this delay continuous action, madam, in filing the writ appeal, madam. And there is a delay of 31 days, madam, in
30.
filing 31 days, madam.
31 days.
I have explained the delay in the paragraph 2 of the IA, madam. My learned friend
Here
does not
also
have any
we-
objection, my lord. Yes.
Who is there? Yes,
Okay.
you are representing respondent.
I am representing my lord.
Two, 3, and 4.
My lord, 2 and 4, my lord.
Huh?
2 and 4. 4.
The Commissioner Departmental Promotion Committee. You are not representing the number 3.
No, my lord, it should have been, my lord, I believe, my lord, chairman, my lord.
Yeah.
Just comment.
Chairman.
It should have been chairman, madam. Madam, I will correct it, madam.
But whether here the handwritten correction is still practicing, here principals it is totally
The filing application.
yes,
madam.
stopped. So no handwritten correction, you have to file an I for correction of this one, or I can pass the order, you
Madam.
file a corrected I.
My lord, if my lord pass an order, madam, I will get it corrected in the body of the application, madam.
Correction, handwritten, that is not allowed. We are not practicing that thing in.
Madam,
compulsory.
we will change the page, madam.
Yes,
If-
post title page
yeah.
only you can stay,
Madam,
page number 2. This is post title only, you can still change the post title.
madam.
So it should be chairman.
Chairman.
Otherwise, you are representing 1, 2 and 4, na?
2 and 4, my lord.
2 and. And state is representing
1.
only 1. He लिख it even. Our circuit is done for the petition and also heard Mr. Y. Ira for please the government. Y. Side one, he is representing 2 and 4. Huh? Mr. Kwame is representing 2 and 4. However, it is pointed out by Mr. Kwame, the Standing Council, for the department, that the respondent number 3 is wrongly designated at the commissioner, and it should be the chairman, departmental promotion committee, so and so. In this context, Mr. Saike submitted that he will file a corrected / amended cost title of the petition. Where allowed, Mr. Saike, the counsel for the petitioner will accordingly file a corrected cost title of the petition. Matter will be taken up. When it can be listed?
Tomorrow, madam.
Tomorrow?
We will file today itself, madam.
Tomorrow billing matter
Day after tomorrow, madam.
I don't know whether the other division bench matter is there tomorrow or not, so let it be on day after tomorrow.
Madam.
Let it be on day after. Make a correction, simple correction.
Madam. Sorry, madam.
Party. This matter may be listed on 16th December.
37.
Yes, sir.
You have taken consent of the other. Respond number 2 and 3.
Only 3.
Only.
Comment is there for 1 and 2. 16th December.
The request made by the Union Council for the petition. With the consent of the other side, the learned council for the petition with a request for adjournment of the matter. Where allowed. 16 will do? 16 December. 16 December?
Yes.
Oh, I thought 16 November. Okay, then 16 December.
16.
Okay, well, listing it on 16 December.
Hello.
May I please your lordship? I beg to mention item number 11 of today's
Item
list.
number 11.
11 of today's list, my lord. In this matter, we are going to file our reply, my lord. We need some time. And I've taken the consent of the other side, my lord. As well as item number 45 and 47. 45 to 47 also. We are going to file.
No. Item number 11, you want an adjournment.
Yes, my lord. In this matter, we are going to file our affidavit. So we need some time.
Affidavit, you're for the appellant or?
Yes, I'm for the appellant, my lord.
Affidavit in the sense rejoinder or rejoinder affidavit?
Yes, my lord.
You are MS?
And Gogoi.
I heard MS and Gogoi, the learned counsel appearing for the appellant, and also heard. You are appearing this one, you? You know, So and so, the government advocate for the respondent. It is submitted by MS Google that she needs some time to file their rejoinder affidavit, prayer allowed. When you will be-
16 December, my lord.
Same, 16 December.
Yes, ma'am.
You want to fix it?
Yes, my lord.
16 December.
As well as other
And what about?
item
other
number
matters?
45 to 47. We are going to file an additional affidavit today itself, my lord, during the course of the day.
45, 46, 47.
Yes, my lord.
I'm appearing for respondent number 4.
In all matters?
Yes. 2 minutes.
45, 47.
No, you're for 45, 46 and 47.
Yes, ma'am.
It's all connected.
Connected
Ah,
matters.
yes, connected. So you are appearing for?
Bid petition 71.
71.
70 and 71, I'm appearing. 58, I'm not there. Government is there. in 58.
Same for Hard Mr. and so. You also heard Mr.
It's enough.
D. Senapati. The counsel for the respondent number 2. And T. Wambi. Counsel, the government advocate for the other respondents. With the consent of the other side, Mr. MS Google paid for an adjournment stating that you are going to. file the
Additional affidavit.
additional affidavit during the course of the day. So here also you want
16 December.
let them all the matter be listed on 16 December. Okay.
Highly authorized.
Your Honor. Your Honor, I beg to mention unlisted matter. This is in regards to item number 32. It is a IA for seeking some time.
Item number 32.
32 is election matter.
Now it's already listed.
Yes, no, Your Honor, I have filed it. I am mentioning for unlisted for taking up.
No, in orders column, item number 32 is there in. orders
Yes, yes.
column. Then
No, I am filing this IA for seeking some time for filing a written objection. I am for respondent number 1. IA is
now
mandatory.
you're going to file an IA now.
Yes, I have filed it. I have already filed it. I am,
So can we wait for that IA or what do you want to say?
no, this may be taken up along with item number 32. I have already filed it.
Okay, it will come.
Yes,
Okay.
yes, oblige.
May it please, Your Lordship. Your Lordship, I beg to mention for unlisting one writ petition. It is in connection with the transfer matter. So it may be listed for motion for today, Your Lordship.
Division bench, single bench, no, no, more different. No, it division bench open a single bench. Single bench open. It would only tomorrow there are lots of matters that will fix. So tomorrow today may not be possible.
Your Lordship,
Maybe
it,
tomorrow or day after.
Your Lordship, it won't take much time, Your Lordship.
No, time is other way, but you see the list, 47 other matters are still there.
Yes, Lordship.
So maybe listed tomorrow also.
Yes,
Tomorrow
Lordship.
may be listed.
Yes, Lordship.
Your
Highly
Lordship,
obliged.
Your Lordship, I would like to mention item number 12, Your Lordship.
Item number 12.
Yes, Your Honor.
Yes.
I'm for respondent number 2 and 3. We'd like to
You are for
file.
respondent number 2 and 3.
Yes, Your Lordship.
Who is for the appellant?
Your Lordship,
You
but I
want-
have from the other side, Your Lordship, already. We
You
will
have
be filing
informed the
additional
appellant
affidavit.
side.
Yes,
Appellant
yes.
you have informed.
Yes, Your Lordship.
Tatak was there for the appellant. He is available here. Item number 12 for whom available for item number 12. Item number 12. You are for the government?
Yes.
1 and 2. You are for 4, na?
No, Your Lordship, 2 and 3. Item number, let me just,
2 and 3.
2 and 3, Your Lordship.
Some 1 and 2 couldn't apply.
Oishi Enterprise, Your Lordship.
Government is representing 1 only.
1. Yes, Your Lordship. 2 and 3 are for the Pasigat Smart City, Your Lordship.
Here you are applying for 1. You're for, you're for, I mean, appellate,
Yes, Your Honor.
sorry, petitioner, no? You're for-
Yes, sir.
So they're seeking adjournment
Yes.
with the consent of the RSA, the learned counsel for the.
2 weeks time, Your Lordship.
Representing the respondent number 2 and 3, Mr. N. Khera, wait for an adjournment to which the petitioner side as well as the respondent, government respondent has raised no objection. List the matter after 2 weeks. You need 2 weeks or 3 weeks? 2 weeks.
2 weeks. Your Lordship.
List the matter accordingly after 2 weeks.
Highly obliged. Lord.
Blush.
May I please, my lord. My lord, I'd like to mention this item 28, my lord. My lord, item 28, this is a new filing.
28 is along with 27. I
Yes,
think.
27. In fact, 27 was filed earlier, but 28 is a petition, my lord, arising of the subsequent order passed by the deputy commissioner, my lord. Until that, my lord, it has not been listed. It is being listed for the first time, but it has been wrongly listed in admission, my lord. May I pray, my lord, this may be taken up as a motion item.
Both the matters or the matter item number 28 only.
28, my lord. 28 is
should
of
be
course
listed in the
connected.
motion column.
Yes, it should be in the motion column because till that, my lord, it has not been taken up. Ma'am. It has been wrongly listed along with item 27, ma'am. So even, so may I pray, my lord, this may be taken up as a motion item, ma'am.
Pardon, Mr. D. Suki, the learned
My
counsel
lord,
for
my
the.
lord, today, my lord, today is, my lord.
Today may not be possible. Let it be tomorrow only. Let it come, the matter be come tomorrow in the motion column. Today may not be possible. Election matters are there in fact. May not be
My lord,
possible.
since it is already listed, my lord.
May not be possible. That's what I'm saying.
My lord,
Tomorrow
then
it
let,
will come. It will come tomorrow.
will-
By stick will come.
my lord, then let it come on the list, my lord. Otherwise, I will see whether it reaches or not, my lord.
Pardon?
My lord, then let it remain there, my lord. Will
Here.
here, my lord, today also, my lord. Otherwise, it should have been in the motion, my lord, but it has been listed in admission, so.
That's what I'm saying.
Yes.
Tomorrow it may come tomorrow also. No issue. But today may not be possible.
No, let it call then, my lord.
Okay.
May I please proceed?
Yes.
Lordship petitioner is a 75% visual impaired person, my lord. And he was, my lord, appointed as SSA teacher, my lord, in the year 2014. After his appointment, my lord, he was serving till 2018, and on 2018, while he was serving as SSA teacher, he submitted a representation to the Honorable Minister, then Honorable Minister Education, my lord. Based on that representation, my lord, on that representation, my lord, the petitioner prayed for regular appointment in the PRT, my lord. PRT means this primary teacher, as a regular teacher, my lord. During, my lord, his service as assistant teacher, my lord, in the year 2014, my lord, he participated in the selection process for PRT, my lord, regular teacher, my lord, regular primary teacher. And in that interview, my lord, selection process, he was placed in the waiting list, my lord. And in the subsequent year, in the year 2015, my lord, again, there was advertisement for this primary teacher and trained graduate teacher, JT. So in that what interview, my lord, selection process, he also took part, and he was again placed in the waiting list, my lord, in both primary teacher and JT teacher, my lord. My lord, but he was not given appointment, my lord, on the basis of that waiting list, my lord. So therefore, my lord, since he was qualified, his petitioner is a master degree in political science, my lord. And beside it, my lord, he has done his diploma in elementary education. And thereafter, my lord, in the year 2014 and 15, my lord, he has also cleared the teacher eligibility test, my lord. So therefore, my lord, he has all the qualification, my lord, to be selected as primary teacher, my lord, not even for JT teacher. Therefore, my lord, since he was serving in the department as a contract assistant teacher, my lord, in the year 2018, he filed a representation before the
Since when he
education,
is in contractual basis?
my lord.
Since when he is in contractual basis? Since when he is in contractual basis?
From 2014, my lord,
From 2014 only.
2014.
Okay.
Now, after the submission of representation before the Honorable Minister of Education, he was given appointment, a regular appointment, my lord,
Hmm.
on 2/11/2020, my lord, as a regular primary teacher. Thereafter, after his regular appointment in the year 2020, my lord, he was serving as regular primary teacher. While he was serving as a regular primary teacher, my lord, the authority, respondent authority, my lord, had issued so cause notice dated 25/12/2023, my lord. Whereby, my lord, he was directed to furnish reply to this so cause notice. The so cause notice was that, my lord, on the subject matter of the so cause notice was that, my lord, my appointment was not made through proper selection process, my lord. There was some fake appointment order involved, my lord. So therefore, I was asked to show cause as to why my service shall not be terminated, my lord. Thereafter, my lord, after receipt of the so cause notice, my lord, the petitioner, he has given his reply, my lord, written reply to that so cause notice, my lord. In that so cause notice, my lord, the petitioner has explained everything, my lord. Everything, my lord. And that I will, my lord, later come to, my lord. Thereafter, my lord, on after this submission of the so cause notice reply, my lord, I was of the impression, my lord, the authority now are convinced. So why they are allowing me to this continue with the service, my lord. But suddenly, my lord, on 13/9/2024, my lord, there was the authority has issued termination order. To me, thereby terminating me from the service, my lord. Now, I am agree by this termination order, my lord. My contention is that, my lord. Of course, my lord, I also understand there is so cases pending before this honorable court also, my lord, regarding this illegal, this appointment and all, my lord. But my case should not be equated with all those cases, my lord. My case is, my lord, my appointment, regular appointment was made purely on the basis of my representation, my lord. There, after receipt of my representation, my lord, there is a file noting, my lord, of the department, my lord. In that file noting also, my lord, it shows that, my lord, my case.
Okay, yes.
My lord, in this similar cases, they are all around, my lord, more than 297, the illegal appointees has been terminated. And most of them have approached this honorable court, and there's none of the case, the interim order has been, no any interim order has been granted in any of the case, my lord. And moreover, in the entire Arunachal Pradesh, in the 13 various district of the state, the case has been registered, vigilance case, SIC case, and then now the investigation is progress, my lord. Now, regarding this termination, my lord, although there may be no foul play on part of the petitioner, but the fact of the matter is there's a fact, my lord. The appointment order, regulation order itself is not, it itself is a fact, my lord. It's not been through the government approval. So that's why this termination order is in there. So in that case, my lord, we can consider on merit, my lord. In his case, if it can be segregated, we can see it on merit after considering the case on merit, filing counter appeal. At this stage, my notice may be issued, my humble respectful submission.
My lord, my further submission would be that, my lord, I have already this across 36 years, my lord. I cannot sit in the competition examination anymore, my lord. If I am terminated, my lord,
So he is saying that your matter may be a bit different from the other matters, so it
Yes.
may be considered, but let them file after.
Yes,
filing
madam.
the matter, let the verification of the file and all, they may file the counter affidavit.
Yes.
In that case.
In
matter may
merit,
be
we can
considered
consider, yes.
Disposed of also, particularly your case, maybe matter may be different, but those appointment orders and all, passed by the department concerned are all fake and illegal as per the government. So let us see. At this stage, we are issuing notice and if they file the counter, and then they on that basis only. But
we'll consider
interim,
merit.
it's not a case of interim. That means.
my lord, then the matter may be fixed after 2 weeks, my lord. And I will humbly request my client to file his affidavit as early as possible, my lord. But because, my lord, since I have been terminated, my lord, I have a family also, my lord.
Yes,
I have to
obviously.
feed them, my lord. There is no other person in my family to.
Administrative come to learn council for the petition, also administrative town. The learned standing council education department representing the respondents. This is an application. That would be date 6 of the Constitution of India, challenging the legality and validity of the impugned termination order, number SEDN 21017 bracket of 12/3/2024 dated 13/9/2024, whereby the present petition has been terminated from his service full stop. Mr. P. Thakur, the learned standing counsel for the education department, submitted in this regard that after consulting and verifying the official records, the case of the present petitioner may be considered, and accordingly he sought some more time to file their counter affidavit. Prayer allowed, no formal notices required to be served on respondents. However, the requisite copy may be furnished during the course of the day. Let the matter be listed. You want any fixed date here?
Well, let it be after 3 weeks, my lord.
After 3 weeks.
Well,
If we can have fixed date after 2 weeks, my lord.
let it be after 3 weeks.
After 3 weeks, any
bec-
date or?
No need, my lord. We'll just let it be listed.
You're listing it after 3 weeks.
Deeply obliged.
Much obliged.
Your Lordship, page number 15. This is a transfer matter, Your Lordship. Page number, Your Lordship may come to page number 15. This is the order which has been impugned. Now, it reads,
From your, yet with the transfer order, the earlier, the post of, since when you were posted there?
I am
in it?
posted at Lazu under Khonsa division.
Ah.
Khonsa division. I am aggrieved by the impugn order, office order, which has been,
Because, but the transfer is, it's a
that is
the condition of service and it's.
absolutely true, Your Lordship. That is needless to say. That is an incident of service. That is inbuilt in every service, government service, Your Lordship. But then it is a settled law that every transfer order has to be issued while maintaining the policy of transfer, Your Lordship. Now, two basic principles, Your Lordship. It has to be issued in the interest of public, or there has to be administrative exigencies. Either of these two conditions, or if these two conditions are not there, then there has to be a requisition from the concerned employer, Your Lordship. Now, when we go by the bare language of the office order, this is a so-called transfer order. I'm just reading, Your Lordship. Nowhere it reflects that it has been issued in the interest of public, nor it has been issued in administrative exigencies, Your Lordship. Now, it reads, Sri Kijan Rangsong, Junior Engineer C, is hereby transferred from the office of the Executive Engineer, Khonsa Division, PWD AP, and posted to the office of the Executive Engineer, 0 Highway Division, PWD, Arunachal Pradesh, with immediate effect. From this single line so-called transfer order, it nowhere reflects that it has been issued in the interest of public, nor it has been issued in administrative exigencies. In a similarly situated case, Your Lordship, this Honorable Court had an occasion to consider such kind of a case. Page number 20 here. Page number 20. That is writ petition number 94/2024. This is the same person, same authority who had issued in respect of some other person who was working as a junior engineer. Page number 22 is the relevant part. Without entering into the merits of the matter, the Superintending Engineer, Coordination, Public Works Department, Arunachal Pradesh, Itanagar N/or any other authority competent to order transfers like the one involved in the order dated 23/2/24 is hereby directed to take on record the said representation dated 1/3/24 and to dispose of the same by way of issuance of a reasoned order. Such representation be disposed of by the superintending engineer or any other authority competent in the matter within a period of 1 month from the date of receipt of this order, and the decision thereof be communicated to the petitioner in the form of a speaking order. Now, Your Lordship, para 3, page number 21. I'm coming by traveling back to page number 21, Your Lordship. Para 3. The counsel for the petitioner submits that the transfer of the petitioner was ordered without there being any administrative exigencies or public interest involved. The learned counsel for the petitioner, by drawing the attention of this court to the order dated 23/2/24, has submitted this said order also does not reflect that it was passed in view of any public interest or any administrative exigencies. It is further submitted that the petitioner had submitted a representation before the authority issuing the order dated 23/2/24 on 1/3/24, and the same is said to be pending till date. Now, this is a similar case. In that case also, the issuing authority was the same person, same issuing authority, and this is a similar case. In that case, this Honorable Court had directed the respondent authority, the issuing authority, to consider the representation, and that petition was disposed of at the motion stage itself. Now, similarly, in this case, since there is no any mention or reflection of
Here also you have filed any representation?
representation has been filed, Your Lordship. My representation has been filed before the issuing authority, and which has been received by the issuing authority on 25/10/24, page number 16. Your Lordship. Page number 16, Annex 2. That is still pending adjudication. I have a right to file a representation which has but not been considered and disposed of till date, Your Lordship. That has been received by the authority on 25/10/24. Your Lordship.
Your transfer order was on dated?
My transfer
Your
order is at
transfer
page number
order-
15, Your Lordship.
No, date was?
That is 9/10/24, but then I have received
9/12,
9/10/24.
Huh?
9 October,
9th of October.
9th of October. Still no release order has been issued against me.
Yes.
My lord, even to make out a case for disposing of the representation, the petitioner has to have some grounds, my lord. Here,
first of all, my lord has rightly pointed out, he has not even mentioned from when he was posted in this place of posting, last place of posting. There is no mention. There is I will have to take instruction on that. I believe there is a deliberate suppression of this, my lord. He might have overstayed, my lord. Otherwise, this should have been mentioned that it has, he was posted there for, on this date. So, my lord, for today, let me take instruction on which date he was earlier posted in that place. And if he has overstayed, he does not even make out a case for disposal of his representation.
Because there's no mention at all where,
Yes,
when
ma'am.
day is it posted there.
Your Lordship, my last submission on the basis of the submission made by the learned counsel for the state, my petition is absolutely based on the impugned transfer order. That is not on merit, Your Lordship. Because it is true, it is a settled law that transfer and posting is an incidence of service. One doesn't have any right to claim to remain in a particular place of posting for a particular period of time as he or she wishes, Your Lordship. That is at the prerogative and at the discretion and the sweet will of the authority, appointing authority to place me under transfer, even before the expiry of the directives, before expiry of the 2 years or 3 years period. That is not mandatory. That is simply a directive, Your Honor. That is not mandatory. But then that doesn't mean that the authority can act at their own whims and caprices and pick and choose any person at their own whims and caprices. That is the reason why this petition is not on merit. My submission, that is on the basis of the submission made by the counsel for the respondent, official respondent.
My lord, he is absolutely right. Let the records be called for whether there is a arbitrariness in this or there, his transfer is in public interest, ma'am. That's all, ma'am. Otherwise, every public
See,
interest is,
order doesn't say so.
yes,
But
but
that doesn't mean that.
Yes, my lord.
Yes, what is the public interest or
Yes,
whatever,
ma'am.
whether he was posted
It
there
will,
for more
the
than 3
reasons
years
will
or-
be in the records, my lord. So let, although it does not say public interest or administrative exigency, let the records be called for that in that event.
That is in order
That
to avoid.
every public interest or that it's not required every time to be reflected in the transfer order. Records will speak for that.
Oh,
First of all,
that
we
is
will
the-
have to
yes.
show that when he was posted there, madam, even for making out a case for disposal of his representation. Madam. So
That is the-
By the time, you take instructions also, okay, his representative is still living and as per his submission, there's no release order till now. So still pending is there. I mean, representation is still pending before the authority concerned. So let you call for the record and by that time you also take instructions from the authority and file in your counter. We'll see to it. If there is anything, then it's okay. Otherwise, it can be disposed.
yes, my lord, there may not be any interim order, my lord.
No, that's what I'm saying.
Yes.
We are not going to pass any interim.
Yes, ma'am.
Let the record be called. We are going to fix maybe short date also.
Yes, my
maybe
lord, next Monday, madam.
Next Monday can be fixed, yes. Heard Mr. C. Manton, the learned counsel for the petition, and also heard Mr. R. Ratan, the learned additional AG, representing the respondents. This is an application under Article 226, read with Article 227 of the Constitution of India, against the body setting aside and quashing of the impugned transfer order dated 9/10/2024, issued by the Superintendent Engineer, Coordination, PWD, AP Duncan. It is submitted by Mr. Montauk that the transfer order itself is illegal and there is no mention about any public interest or exigencies in the order itself, which was passed by the department concerned by transferring the present petitioner from his present place of posting. Further, it is submitted that one representation has also been filed before the authority concerned on 25/10/2024, which is still pending for disposal. And till then, there is no release order for the present petition. Next paragraph. Mr. Ratan submitted the learned additional PP submitted in this additional AZ submitted in this regard that there is nowhere mentioned that since when he was posted in the earlier place of posting, and there is nothing to make out any case from his representation. However, he submitted that the records may be called for, and by that time, he may be allowed to take instructions from the authority concerned to file his count. Considering the nature of the matters, let the matter be listed Monday, Monday, enabling the respondent to file their counter and to also call for the case. Record to call for the we call
Your Lordship, I beg to make a submission that since there was prayer for interim, so that has not been considered at this stage. But there may be a specific mention that the prayer for interim be considered, shall be considered on the next day when the record arrives.
prayer for interim may be considered on the next date of listing of process. Monday, peak on time. Monday's not time. 11.
May I please, Lordship? The petitioner before your Lordship is challenging the impugned transfer order, whereby the petitioner has been transferred just after 7 days of his service at present place of posting, Lordship. And the impugned transfer order was in violation of the policy guidelines framed by the Department of Education units. So, Lordship, may I take you to the first transfer order at page number 17.
17.
17. This is the first transfer order. By this transfer order, Lordship, the petitioner who was serving as a PRT, primary teachers at government NSCBAB school Gaching is hereby transferred and posted from government NSCBAB school Gaching to government upper primary school Karle under Monigao Sarkar. By this transfer, he has been transferred to Karle upper primary school, Lordship. And pursuant to this transfer order, the petitioner he has been released by the head teacher on 11 at page number 18. 18, Lordship. Type out copy is page number 19. With reference to the order number so-and-so, Sri so-and-so is being transferred to government primary school Karle. Hence, Sri so-and-so is released from his end to join UPS Karle. And accordingly, Lordship, page number 20. Join. This is the joining report at Karle. Now, thereafter, Lordship, most surprisingly, impugned transfer order issued on 19 September. He is joined on 12 and impugned transfer order was issued on 19 at page number 21 and name of the petitioner is reflected at serial number 70, page number 23. 23. Serial number 70.
70.
70.
70.
70. Series so-and-so, PRT, Yesing, transfer to at the disposal of DDS Tirap district. He has been transferred from Mechuka, Siomi district, Monigao circle to Tirap district within 7 days, Lords. Now, Lordship, the Department of Education, they have framed their own guidelines and which was notified on 10 February 2020 at phase number 24, whereby they have framed a policy guidelines for transfer and posting of teachers. First, I want to show you the vision of this notification, this draft policy, Lordship, page number 24. Short title, it was notified on 10 February 2020 by number SEGN 276 and 2019. And just down below, short title, the policy will be called by the name Teachers Transfer and Posting Policy 2019 and 20, and vision to ensure equitable, need-based distribution of teachers to protect the academic interest of students and optimize job satisfaction amongst the teachers in a fair and transparent manner. This is the vision. And Lordship, I'll take you to the page 27, transfer calendar. 27. Here also, Lordship, how the transfer order has to be affected, that has been, they have prepared their transfer calendar. From this clause 8, the following time schedule shall be followed for the purpose of clause, subclause para 2. Clause 8, subclause 2. The following time schedule shall be followed for the purpose of transfer and posting every year. This is the year calendar, how transfer has to be effected. A, from 1st December to 31 December. Here, from this clause, Lordship, the transfer of teachers, the transfer process has to be initiated from the 1st December and it will be ended by 31 May. Clause F. Disposal of all transfer related cases and process. It has to be. Now then, Lordship, next page, page 28. General guidelines for transfer and clause 3. Minimum service period in a school for seeking transfer shall be 3 years and maximum service period in a school shall be 5 years. This is the guidelines, Lordship. But in my case, Lordship, I have been transferred out within 7 days. Therefore, may I humbly pray that, Lordship, at this stage, notice may be issued and this impugn transfer order may be stayed.
Yes, Mr.
Malam.
Because within 7 days, it got transferred.
Malam. Still returnable day only.
Along with the process of the petition. And also have Mr. P. Raman, the standing counsel of the Education Department, representing the respondents. This is an application. Article 226 of the Constitution of India against challenging the legality and validity of impugn transfer order dated 19/9/2024 in respect of the petition issued by the Commissioner of the Modification Department, Government of Arunachal Pradesh. It is submitted by Mr. Logan that the present petitioner was earlier got transferred from his service and on
28
August 2024, and accordingly he joined in his new place of posting.
On-
Accordingly, he joined on
12/9.
12/9, so and so. 12/9, but very surprisingly, only after 7 days of his transfer order, and the transfer order is being passed by the department concerned, transferring the present petitioner within 7 days from his date of joining in his earlier place of posting, which is against the rule frame, like the, which is against the your transfer rule is name is
Lordship,
Page 24, man.
page 24. Serial number 70. Or guidelines.
transfer policy and the guideline issued by the Government of Arunachal Pradesh Department of Education.
Department of Education.
Wherein, as per the clauses of mentioned in the state transfer petition, one cannot be transferred within 7 days from his place of posting, from 7 days from this date of joining. Accordingly, he prayed that an interim relief may be granted to the present petitioner. In next petitioner by staying the order of transfer dated
19/9.
19/9/2024
2024.
by the respondent authorities. In this context, Mr. Dagun raised no objection and however submitted that you want to
Read
file,
argument.
no, you want to file any counter,
Yes, I'll file count.
file the counter affidavit and according to some of time. Please matter, your petition, I mean, order has been stayed and.
Respect of petitioner.
Yes,
in respect of-
of the petitioner.
Yes.
When it can be listed then?
My lord, after 3 weeks, my lord.
After 3 weeks, list after 3 weeks. We are listing it after 3 weeks.
Yes.
Deeply obliged.
Please, my lord. My lord, this item number 4 and 5 are similar matter. These are also pertaining to the my lord transfer matter. But here in this case, my lord, we are not challenging the transfer order. Rather, we are seeking for apex of the transfer order, which has already been met and we have not been released by the concerned authority. So, my lord, in item number 4, we are 4 in numbers. We are serving in the same school at Government Higher Secondary School, Bana. And in the meantime, we have been transferred by the director of the school education on 13/8/2024. Lordship will find a transfer order in page number 15. My lord, it is start from page number 14.
This is the transfer order.
No, no. This is the transfer order in respect of petitioner number 1 appear in serial number 7, my lord. Thereafter, lordship will find in the same page number 15, appear petitioner number 2 appear in serial number 5. Again, my lord will find in the page number 17, appear in serial number 3, that the transfer from Government Higher Secondary School, Bana is coming district to my lord, Baluku West coming district. Then finally, my lord will find in page number 18, appear in serial number 3. And finally, page 21, appear in serial number 3. So, my lord, we all are the PGT teacher, my lord. And in the now, my lord, in view of this transfer order, we have been released from the concerned headmaster and the particular school. Now, what is need to be complete is, my lord,
All these transfer orders on 13th of August.
my lord.
All the transfer orders are of 13th of August.
30th of August.
Yes, 13 August, my lord. So, my lord, what is required is, my lord, the controlling officer, that is the deputy director of school education, is yet to, my lord, make the final order so that we can move from the, my lord, move to the new posting place, my lord. That has not been done. So therefore, we are under the pendulum, my lord. Despite, my lord, we have been already released from the concerned school and the reliever is already joined there. But due to fulfilling of these formalities, my lord, we are under the pendulum and
So release order is already issued.
But for that,
What prevented you from joining?
but the final release order is required from the controlling officer, my lord, that is the deputy director of the school education, my lord. So, my lord, without wasting the time, my lord, I am to inform this honorable court. This is the, my lord, the cover-up method. In the recently, my lord, out of the same transport and the same respondent, my lord, this already been issued from this honorable court that was disposed on the, my lord, motion stress itself, whereby, my lord, this transport was made on the same day, my lord. So thereby this was disposed, whereby, my lord, the 15 days time was granted to the respondent authority to dispose of, my lord. So in this line, my lord, this can be disposed of today, sir.
Yes, Mr. Attorney. Why don't find?
My lord, that is why, my lord.
No, but is it necessary because he has already been released and his
Only-
reliever has already joined there?
My lord,
In that case, whether that is necessary?
only for last pay certificate has to be issued by the DDSC. Deputy Director School Education. For that purpose, otherwise he has been released, they have been released from the concerned school. Only for preparing salary in the transferred area. The last pay certificate is required. Maybe because of that problem.
Along with service book. So that formalities is yet to done.
I mean, LPC has not been issued
My lord.
till now. Last pay certificate is not.
My lord. That is to be issued by the my lord, respondent number 3, Deputy Director of School Education, my lord. So that only hampering us, my lord, making us pendulum in the urgent case.
And when the other, you have been released from your, that other earlier posting?
My lord,
Because there may be a service break otherwise, that's why I'm asking.
my lord,
When you got released,
my lord, oh, pardon? My lord, we have already released on 21 September. It appeared in page number 20, my lord.
21 September.
Yes, my lord.
In 21 September only you got release order.
Yes, we have been released from the my lord, concerned headmaster. But the last payment certificate with recommendation from, because this is my lord, inter-district transfer. So the respondent number 3 is yet to make this my lord formalities.
My lord, just I think, my lord, I need to take instruction. The earlier case, my lord, it was disposed of, my lord. I made a communication, telephonic discussion with the authority. In that case, there was some communication gap, my lord. I don't know exactly this. I could not contact the authority also as to why they have not been released today, as on today, my lord. My respect to him, can this matter be released after day after tomorrow? Convinced? We'll take instruction.
Because
Otherwise, no
what
issue,
I-
man.
As I'm asking just now, see, the headmaster has already released.
Yes, that is well.
On 21/9. So since 21/9/2024 till date, they have not joined. So there may be a service break also. We don't
My lord,
inform.
that is why, man.
So that has to be looked into. So you
Well,
take instruction.
My lord,
Otherwise, the LPC and these are the order formalities.
my lord.
Department can do immediately.
My lord,
Harm and issue. Day after tomorrow matter may be fixed. By that time,
Otherwise, the
we
my
may
lord,
insist the department concerned also
my lord.
to issue all these things so that can join.
Well,
Or if you can place us,
after-
place before the court those the LPC, and if it is already issued, then it's okay.
My lord.
Otherwise, there may be service break also for them. It will hamper their service career. So we are fixing it on day after tomorrow. Let him take the
my lord,
and I have,
since I'll be out of,
he may insist the department also to issue your release order, LPC, whatever the formalities.
my lord.
So that
Otherwise,
immediately it can be placed.
so my lord, in such situation, my lord, let the matter be fixed on 8, man. I'll be out of the station for my lord.
Eight.
No, it's 8.
Yes, 8 of this month.
8 of
8 of this month.
8,
That is
8.
Friday.
days. 2 days, 4. 8
All right.
on Friday.
Friday.
Oh, list on Friday. I will request made by the students on list. Because it's very strange. Why you?
Exactly, my lord.
Yes.
Unnecessary. It's.
Ah. But have you tried to join there without your LPC support? You have not tried also, na?
So,
Join your new place of posting. Have you
Madam.
tried to join there? Whether you have filed any application for joining there?
exactly,
Not
my
yet.
lord. But the, my lord, the first criteria to join there, my lord, along with my service book
See,
and the.
whatever. Have you approached the authority, the new, the headmaster and all?
Nah.
You have not.
No,
You have
my,
not approached the new headmaster
My
or the
lord,
school
so,
authority.
because my lord, this, for, the formalities has not been
Formalities can,
considered.
It's okay, but you could have approached the authority that we have already released. Because otherwise there may be a service break for you also, not that. Okay, we are fixing it on 8.
My lord, item 5 is also same.
For both 4 and 5.
4 and 5. All right.
Yes, item number 6.
May I please, Lordship?
Yes.
Lordship, this is pertaining to transfer order. Lordship, this is a case where the government has done their every possibilities of illegality, arbitrariness, and malafide in retaining the private respondent number 4 at same place since last 9 years, 6 months and 7 days. But the petitioner has been ousted from that subdivision. May I take you to the Lordship first transfer order? Page number 26. This is the initial transfer order where the petitioner has been transferred from Alo subdivision to Longdon. Then pursuant to this transfer, he has already joined. He was transferred on 8/7/2022 from Alo subdivision to Longdon. Then thereafter, Lordship, after completion of 2 years of normal tenure, the petitioner has been transferred from Longdon to Kanubari on 8/10/2024 at phase number 27. Annexure 2 series, page 27. The name of petitioner is at serial number 8. And private respondent number is at serial number 9. Where, Lordship, the petitioner who was serving as A Longdon subdivision has been transferred to Kanubari subdivision as A at serial number 8 and serial number 9. The private respondent number 4 who was serving at Kanubari was transferred to SE Dafurujo Circle. And it was issued on 8 October. And pursuant here to Lordship, the petitioner has joined at present place of posting at phase number 28 on 9th October 2024, page number 28. Now, thereafter, Lordship, even after joining of petitioner, the respondent number 4 was reluctant to hand over the charges to the petitioner despite of his joining. Accordingly, it was intimated to his superior officers, executive engineer, regarding non-handing over of charges. Accordingly, order was issued at phase number 29 by the executive engineer. Page 29. Hereby, by this order, it was directed to the private respondent number 4 to hand over pool charges of assistant engineer, WR subdivision Kanubari to the petitioner newly joined AWR SD with immediate effect. Now, despite of this also, Lordship, charges was not handed over. Now there is a government office memorandum, next page 30, Lordship. May I read just 2 para from this office memorandum. It consists of 7 para. Subject, Lordship, page 30, Lordship. Subject, joining and relief and transfer of charges of officers on transfer in certain clarification issued regarding. A government servant holds office at the pleasure of the government. Government issues order regarding transfer and posting of officers from time to time as per the administrative requirements. It is clarified that once transfer and posting order are issued by the competent authority, no further order or permission is required for the officers to join in his new place of posting. Means after issuance of transfer order by the competent authority, the relieving officers has to immediately join to his new place of posting. Now, Lordship, clause 4. In the event where the charges are not handed over, how it can be taken ex parte charges that has been provided in clause 4. May I read clause 4? In cases where the relieved officer does not hand over charge to the relieving officer, when he comes to join, the relieving officer will assume charge of the office unilaterally / ex parte so as to implement the government orders
and to enable the officers to discharge his duties and responsibilities without delay. The relieved officer will stand automatically relieved once the relieving officers assume charges. Here means once the relieving officers
Yes.
taken over the charges ex parte, the officer already stand automatically relieved. Now pursuant to this office memorandum, Lordship, I have taken the ex parte charges and it was intimated to my authority at page 32. Intimation, page 32, Lordship. On 14/10/2024, I have taken the ex parte charges. Intimation regarding ex parte charges, assuming as Assistant Engineer, Water Resource Subdivision, Kanubari, FE, in terms of the government office memorandum, so and so, so and so. By this intimation letter, I have taken the ex parte charges from the private respondent number. Thereafter, certificate was issued regarding my performance and duties at my present place of posting by my authority on 24 October 2024. Now, thereafter, Lordship, most surprisingly, this impugned modification order was issued. I am aggrieved by this impugned modification order, Lordship. Page 36. Even after my joining, I have assumed the charge ex parte. Thereafter, on 14th, but this impugned order was issued on 28th, Lordship. May I read, Lordship? Page 36. In partial modification of earlier order of event number dated 18/10/24, the Governor of Arunachal Pradesh is pleased to order transfer and posting of the following assistant engineers under Water Resource Department as per places shown against each below with immediate effect until further orders. Now, petitioner is 1, serial number 1. Under the order transfer and posting, Kanubari subdivision as A, and where I have been posted, Karsang subdivision, other division, other district also. And the private respondent number 4 at serial number 3, Lordship, Punyo Laling. Now, he has been again retained at Kanubari subdivision, Lordship, by this impugned order. I am aggrieved by this impugned order. Now, Lordship, on receipt of this impugned modification order, I have filed RTA application before the concerned authority, seeking regarding the other related documents and the file notings, how this impugned order was passed. Now, accordingly, Lordship, RTA reply was furnished. And Lordship, through RTA reply, page 38, I came to know that there was 2 UO notes, Lordship, submitted by the concerned local MLA, and now Minister Agri and Allied Arunachal Pradesh. They have submitted 2 UO notes to the authority for retention of the private respondent number 4. And this is not for the first time, Lordship. This is second time retention order against the same person. And he has completed 9 years, 6 months, 7 days at the same place, Lordship. That I will show you their posting order. Now, Lordship, 38 is the UO note, and then 39 is the UO note. They specifically praying for the retention of the private respondent at same place, Kanubari. Now, pursuant to this UO note, office process file noting was initiated at phase number 40, Lordship. May I read, Lordship? File noting. On receipt, page 40, Lordship. On receipt of 2 numbers of UO notes from local MLA, come advisor to Honorable Minister, PWD, Eastern Zone and Central Zone, bearing UO note number so and so, dated 20 September 24, and another UO note from Honorable Minister, Agri and Allied, bearing UO note number so and so, dated 8 October 24, regarding retention of transfer of both the officers. Now, initially, they initiated for retention of both, but when the impugned order was came, I have been transferred out to some other district. Retention of transfer of both the officers, series so and so, as A, WRD subdivision Longdon, and so, private respondent number 4 is Kanubari. In the public interest, the Honorable Minister WRD desires that the proposal for retention of both the officers be proceeded by his so and so in the body of the UO note so and so. Next para. In this regard, it is to be mentioned here that
As per policy guidelines on transfer and posting of all the category of officers, the normal tenure of posting is 2 years by government order number so and so dated 19 December 2008. As per record, Sri Punyo Laling, private respondent number 4, has been posted at Kanubari WRD subdivision on 1st April 2015. Lordship. 9 years, 6 months, 7 days. Now he has been completed his tenure. Further, he has got one-time retention, Lordship, at Kanubari by order so and so dated 2nd August 2023. It shows the private respondent number 4 has been retained at Kanubari for infinite time, Lordship. How long the officers can be retained? Such a long duration. Now, Lordship, next. Hence, on consideration of the proposal above, government may invite legal complicacy. The copies of the policy guidelines of the transfer and posting of transfer is placed at so and this patient list of A is placed at so. However, as desired by so and so, the proposal for retention of transfer and posting of the following assistant engineer and the WRD may be put up for further consideration and obtaining appropriate detention of the competent authority, please. Now, yes, his retention was purely mala fide and on extraneous consideration, not in the public interest. Even various judgment, Lordship, when there any modification of transfer order and cancellation, it has to be with the valid reason. But in this case, in my case, Lordship, the retention was only on the basis of the U or not issued by the local MLS by citing the public interest. How it can be, Your Honor? How the particular officer can be posted, retained at a particular place for infinite time in the name of public interest, Lordship? That too, I have already joined, taken over the charges. Therefore, Lordship, there is a prima facie case of illegal arbitrariness, mala fide on the part of the authority in issuing this impugn transfer order. Therefore, may I be afraid that notice may be issued at this stage and the impugn transfer order may be stayed.
May it please your Lordship.
Yes.
My Lord, in the transfer of posting, your Lordship is aware, my Lord. It is the paragraph of the government, my Lord, whom to place and when to place and where to place, my Lord. Now, here, my Lord, in this case, if your Lordship see, my Lord, the first transfer order, my Lord, that can be construed as a transfer order because the persons was within the division itself, my Lord. Now, Longding division has more than 3-4 subdivisions. So within the same division, this petitioner was in Longding subdivision. Now, so for Longding subdivision, my Lord, is concerned, my Lord, he has already rendered more than 2 years. That is not the issue. Now, issue is, my Lord, within the same district. Now, this order was, my Lord, modified. My Lord, considering, my Lord, the public representative desires, my Lord, that some projects are going on. So, since he is a
9 years.
my Lord, your Lordship aware, my Lord, the public representative, my Lord, they issues, my Lord, notice all these things, my Lord. That cannot be, my Lord, construed, my Lord, automatically. That
That's
doesn't
true.
mean that.
Probably some development projects are not been implemented in Arunachal Pradesh.
My Lord,
Still
suppose
doing all the developmental projects are still in, I mean, up to.
my Lord, those who are
We are
handling the
definitely
development,
concerned.
my Lord, your Lordship may kindly bear with me. Those who are handling the development project, my Lord, he is well acquainted with that. If some new incumbent comes, my Lord, he may have some problem, my Lord. May have problem. I'm not saying that he is not at all, my Lord, incapable to handle that, my Lord, project. I'm not saying that.
But he is more capable.
My Lord, obviously, my Lord, since he's dealing with the schemes, my Lord, the project, my Lord.
What is the progress of those projects now?
My Lord,
Can you tell us? What is the progress of those projects? Now,
My
which
lord,
were he's handling for since 9 years. What are
yes,
those projects, what is the progress of those projects?
my lord. Then you lordship, this since this is coming for the motion stage, my lord, I can take instruction what exactly my project this very gentleman is handling, which demands money his retention, my lord. I can take that instruction, my lord. No, that is not the issue, my lord.
Now, the last transfer order is,
Last transfer order, my lord.
Last transfer of the
no,
lordship.
modification order.
Modification, lordship,
The lordship find page 36,
phase 36.
36, yes, this is the one.
28 October.
36 lordship.
28 October.
28. Just after 19 days of my joining.
19 days.
In fact, this is not a modification of the lordship. After my joining, I have assumed the charge as per OM. Now it should be treated as the fresh transfer of the lordship.
In that case, what do you want to say?
Now, my
Because
lord.
he had already joined. In
Yes,
fact, for that, most probably some communication was also with the department as he was not handing over the charge. That's
Well,
what his process.
My lord, that way he's correct, my lord. Now position is like that, my lord. Now in the same division, man, we cannot have two assistant engineers, my lord. Now the other respondent also they have also assume in view of modification order, my lord. Now that is the problem, my
Private
lord.
respondent,
Yes,
For respondent number 4.
private respondent.
private respondent, my lord.
Just I filed a colors number in the registry.
Okay.
But I have I also already joined the division and taking over the charge ex parte since 30 October.
My lord, both they have taken the
I'm-
expertise charges. That is the main problem, my lord.
The petitioner was busy in applying the RTI then for filing this. So.
You have
office was
already
affected.
joined.
Oh, I have already joined and I have taken the expertise charge. This is the document. So I am functioning as a assistant engineer.
This is the problem now, my lord. In a subdivision, we cannot have two assistant engineers, my lord. Now both they have taken the expertise charges, my lord.
Lordship,
First,
in
my
term,
lord, first, my lord, petitioner, he took the expertise charges. After modification, again, my lord, the private also took the expertise charges, my lord. This is the problem, my lord.
no lordship. Lordship, in terms of that transfer order, I have joined, taken ex parte charges, but this impugn order was issued on 28. I have not been released. How he can take an ex parte charges before my release from the said Kanubar division?
Lots of earlier occasion also I was not released. He has taken when I am taking a CL for 6 days. He is taking the expertise. Now, how he can say that? As per the
I am challenging this impugn order.
Now you want to say in one district, there are two officers now.
Yes.
In
In terms
one
of-
subdivision, there are two assistant engineers, two officers, my lord. Petitioners and my lord, the private respondent, my lord. Because, my lord, both they have seems as per the records, my lord, they have taken the expertise orders, my lord. Now, that is the main problem, my lord.
Now, lordship, here I am challenging the impugn order 28.
Yes, obviously. you have-
Yes. So my lordship has to consider whether this impugn modification order was
Correct.
issued correctly or not. That has to be considered.
That is it.
There subsequent development that lordship, that is always there, lordship.
So, Mr. Nabam, you are representing 1, 2, and 3.
I'm 1 and 2, my lord.
1 and 2.
1 and 2.
3 is 3
3 is
department, I think. No?
Please, executive.
Executive engineer, water resource department.
my name or by designation.
You can represent.
Yeah, 3
I
also,
think.
my lord. Yes,
Three also.
3.
So what do you want, Mr. Nabam? You want any to
No, no,
any counter?
This type of situation,
What?
at the most, your lordship can pass status quo order, whoever discharging duty, let him continue, my lord. Because we need of
Then he is also there.
Yes,
He
Lordship.
has not been released now.
Yes, my
You
lord.
have already joined. So
The-
if status quo is there, then again it will be.
The
Yes,
par-
lordship.
The person who is functioning, my lord, he'll continue, my lord.
No, lordship, status quo will be, because lordship, I am challenging the impugn order 28. So may I humbly pray that lordship, this impugn order 28 may be stayed. Because I have shown the prima facie.
Stay will not, serve your purpose, I think, because he has already joined.
No, lordship, that is, his joining is subsequent development on the basis of impugn order, lordship, after 28, lordship.
Order can be decided on
merit only after giving.
Yes, therefore, Lordship, I am at this motion state, Lordship, I am frank that the impugned order 20th may be stayed because I have shown the illegalities, how they have committed.
Stay will be again a bit problematic because he has already joined.
If
Whatever, rightly, wrongly,
Lordship,
legally,
may I
illegally,
have-
I'm not on that.
May I humbly phrase that, Lordship, if my Lordship stay that impugn this order, then subsequent development will go, Lordship. The question of joining of private respondent does not arise. Lordship.
For that too, we have to hear him, na, if we file this objection. That is the issue, otherwise.
Let him file
From-
in form of affidavit, Lordship, then only consider, Lordship.
So that can be fixed and till the status quo.
I have shown the every illegalities, Lordship, that has been committed, Lordship. I have complied in terms of OM office memorandum. So Lordship, there, if the status quo will definitely, it will cause irreparable loss to me. Difficulties for me.
Then in that case, you file your affidavit in.
Yes,
opposition.
yes, Lordship. Today's
Uh,
motion is placed. In fact, he has not
And,
filed the
we
caveat
are not
also.
Going to pass any status quo or stay.
And
order.
without serving notice, he appeared, Lordship. So may I humbly phrase that, Lordship, impugn order may be stayed.
Mr. A. Nolan, Attorney Counsel for the petition. And also Mr. Anish Nabam, the additional, current additional, AG, and Mr. M. The learned counsel in appearing, we have to the private respond number 4. Then application. Article 226 of the Constitution of India, challenging the legality and validity of the impugned modified transfer order number SWRD/E capital E -22/2015 dated 28/10/2024 issued by Secretary WRD Government of Arunachal Pradesh Itanagar, whereby the petitioner has been transferred out from WR subdivision Kanwari and posted to WR subdivision Khonsa, Khonsa division, and private respond number 4 has been retained for second time at WR subdivision Kanwari. It is submitted by Mr. Submitted by Mr. Loden, the counsel for the petition, that the private respond number 4 has been posted there at Kanubari since 9 years, 6 months, 7 days. And he has been retained in the same post for 2 times. As in pursuant to the transfer order dated, earlier transfer order dated, your earlier transfer order was dated?
Lordship, my earlier transfer was on 8/10/2024.
2024.
Yes.
He already joined and they took charges expired year of the unilaterally, as respond number 4 was not handing over charge from handing over charge as per the direction of the authority concerned. However, but subsequently on 28/10/2024, one modified transfer order has been passed by the authority concerned only on the basis of some UO note by the MLO and the minister, without having any valid reasons and without for any public interest. Accordingly, he prayed that that impugned order dated 28/10/2024 may be stayed during this disposal of the present petition. Next one. Issue notice on the respondent sex. However, no formal notice is required to be given. In this context, Mr. Nawam, the learned additional AG, submitted that that after the modified objective phrase transfer order, the 2 persons cannot be posted in the same subdivision. And accordingly, the party phrase transfer order, the present petition has been transferred and posted in other subdivision. Poster, but no poster. And he had to, and accordingly submitted, he had to take instructions in this regard. Poster. Mr. Bott, the learned counsel appearing for the respondent number 4 submitted in this regard. After the modified slash fresh order of transfer dated 28/10/2024, he has already joined ex parte and took charge of his new took charge unilaterally on 30/10/2024, and hence he is serving in that post. Accordingly, Mr. Bhatt submitted that status quo may be the petition, both the petitioner and the private respondent may be asked to maintain status quo with the same order. In that context, Mr. Lawrence submitted that if status quo order, if the maintenance of status quo order will cause prejudice to the present petition, accordingly he raised objection in that. Next, considering the entire circumstances of this case, we do not find it proper to pass any interim order at this stage, as the respondent number 4 has also already joined in that service ex parte, and accordingly the matter may be the respondents are hereby asked to file their affidavit in opposition, if any, on or before the next date of listing. List accordingly when it can be listed. You want to file your counter affidavit?
Yes, within 2 weeks.
2 weeks,
Very
Lordship,
good, yes.
Lordship, may I submit, Lordship? Lordship, here, my case is, Lordship, I have shown the entire illegalities, and even the government in their office file noting also.
Yes.
They also
yeah.
aware that there will be some legal complications. And now my senior has also made a submission that there will be 2 officers in same division. Now, again, Lordship, without staying this impugn modification order, Lordship, same problem will be there because I have not been released. And what they are-
Stay will be what happened if I pass the stay order. Suppose stay of this order. In that case, again, he had already.
No, Lordship, in this case, Lordship, may I plead, Lordship, in this case, he will go back to his place, Lordship.
Therefore, that also, yes, Mr. Nawab, anything to say in that regard?
You have to clarify.
He will go back, Lordship. We will be their own place, Lord.
Earlier order, I have not joined in the other place, in the same, because I was in the same. So I was not released.
Not
Though he
joining
is
in-
taking the ex parte or ex parte charge.
Now, Lordship, I am challenging
So I-
up to the Lordship impugn order.
So I may be.
Thereafter, subsequent development will become later on, Lordship.
My lord, of the record, my lord, the subsequent development, my lord, yes, this is not a healthy sign. But now considering all this situation, my lord, now both are claiming that they have taken ex parte charge, my lord. Now, as I've said, my lord, in a subdivision, we cannot have 2 officers. There has to be 1 officer, my lord. And there must be officer to function, my lord. My lord, considering this, my lord,
I mean, situation is become.
yes, my
Yeah,
lord.
that's
So if you lordship, my lord, rather I will leave it to lordship, my lord, that either to stay or to pass the status quo order, my lord. Staying, my lord, what will happen? The things will be very clear, my lord.
Yes,
And my lord, status quo order, my lord, the things will be still pendulum, my lord. Because they both have joined ex parte. They both are claiming, my lord, they are discharging because of the government orders, subsequent and earlier orders, my lord. So as per earlier orders, my lord, if your lordship sees the file noting also, it reflects that this gentleman had already assumed the duties, my lord.
Yes, Lord.
Now, as per the subsequent order, again he took the ex parte charges, my lord. So now this is the situation, my lord.
Stay then.
Best.
Otherwise it will affect.
Yes, my lord. So that may be given so that you can go for early hearing, my lord. That will be better.
After considering the facts and circumstances of this case, and the subsequent development of joining of the respondent number 2 after the modified charge unilaterally / ex parte, find it justified to stay the order of modified oblique fresh transfer order dated 28/10/2024 till next date of listing. Then when it can be listed, it is staged.
Immediately by the next week, madam, because if you not stay on that, madam.
Yes, obviously, he may be.
This was.
Okay, then. Next week, in a sense, now say next week, I have 2 days only, Monday and Tuesday. Wednesday, next week, I'm talking about next week. So if it can be fixed within Friday, this week, then it will be because Friday,
Lots of Friday, I will be out of state.
Monday, madam.
Monday, yes, it can be fixed. Monday.
Okay.
No, you have already
Alright.
been stayed.
Yes.
Monday is 11.
Deeply obliged, Lords.
You're for 7, item number 7.
Lordship, yes, Dr. Ardi Tongshi, Lordship.
No, you're for item number 7.
Yes, Lordship.
Nikki. Seven.
Yes, Lordship.
Ah.
Lordship, my prayer, Lordship. Applicant had applied this for the land allotment in 2000, Lordship. In the year 2000, Lordship, applicant applied for the land allotment of that, Lordship, in 2020, Lordship. And it's been almost 23 years that there is no any rejection and there is no any forward movement also, Lordship. And because of this delay, already applicant constructed his residential, Lordship, building, Lordship. And in this regard also, petitioner informed the authority. And despite that, still, this application is pending, Lordship. And now,
But
Lordship,
even after allotment, you have not been. Your allotment order was on 2000?
Lordship, allotment is, Lordship, my allotment, page number 15, Lordship. Page number 15. And Lordship, my prayer is only, I have submitted one representation, Lordship. That just to, Lordship, this representation is page number 30, Lordship.
Page number?
30, Lordship.
30.
Yes, Lordship. My prayer is, Lordship, let it be disposed by authority, Lordship, only. My prayer, Lordship.
Yes,
Any-
what was her name? Yes, Mr. Amended.
Lordship.
Only my
Lordship,
prayer
His
is,
representation is most probably still
Representation,
pending.
Yes.
representation is there, Lordship, but then Lordship,
page
that
number-
he doesn't have any such right that he should be given allotment, Lordship.
no, Lordship,
He has occupied a plot of land and he said he has Lordship applied for it in 2000. Lordship, it's prerogative of the government, Lordship. They will
exactly, Lordship. And Lordship, one
give
of,
allotment or not. Still, Lordship, notice may be
That may
issued.
be prerogative of the government, but the question is that his representation is still pending,
Yes, Lordship. So,
not yet
Lordship,
disposed of.
listen, Lordship, exactly.
no, Lordship, notice may be issued, Lordship.
No, Lordship, that even if notice is issued, Lordship, rejection and carry forward is another thing.
Rejection
rep-
order is there.
No, representation, Lordship. This
Yes,
representation.
the representation is still pending.
Yes, Lordship. Still pending.
Okay, you issue.
That just one notice that directing the this dispose of the this representation, Lordship, only.
Yes, in that case,
Yes, Lordship, if the petitioner wants that, Lordship, that can,
then it will be disposed of.
yes, Lordship.
Yes, land management, anything to say?
Yes, my lord.
Hard, Mr. Yeah, Mr. G.
G Kato, Lordship.
G. Kato, the learned counsel for the petition. Also hard. MS TAT, the learned senior government advocate, and Mr. D. Kamdu, the standing counsel, land management. Representing respondents. This is an application under Article 226 of the Constitution of India. Against for for 1 and 2, Namgita Likhidibo, for 1 and 2, she is representing for 1 and 2, and 3 is Mr. Kamdo. Against the illegal, arbitrary and malified, unreasonable and unfair action in issuance of land allotment order, which was not considered by the by not considering the representation filed by the petitioner before the authority concerned. It is Dick Nixbury. It is the case of the petitioner that in the year 2000, he was allotted a land measuring 300 square meter located at Bomdila town, near district hospital. But till that is land is not allotted formally in his favor. In that context, he also made a representation before the authority concerned on 20 September 2024, and representation is still pending before the Deputy Commissioner of Coming District, Bomdila, which is not yet disposed of, whereby he prayed for the land allotment order from the authority concerned. Ms. Atting, the learned senior advocate, representing the respondent number 1 and 2, submitted in this record that she has no objection if any direction has been given to the respondent number 1 and 2 to consider his representation, which is pending since 29/2024. Mr. Kamduk, the learned counsel, standing counsel for the land management department, also raised no objection if representation is disposed of by the department. With the above observation, it is hereby directed the respondent number 1 and 2 to consider or to dispose of the representation filed by the present petitioner on 29/2024, praying for allotment of the land which is in his occupation since 2000. The authority may dispose of his representation as per law. May the representation dispose of the representation filed by the petitioner at the earliest. With the above observation, the present petition stands disposed. Compliance. Motion of then election matters will say election. That's what this number
May I, my lord? My lord, this is again a transfer matter, my lord. My lord, interim transfer order is page number 15, my lord. Page number 15, my lord. And my name is serial number 20, my lord.
Your name is in serial number?
Serial number 20, my lord.
29.
20, 20, my lord. And my lord, this interim order has been issued solely on the basis of the UN note issued by the MLA, my lord. This UN note is page number 18, my lord. Annexure 2, yes, my lord. Type copy is page number 19. Page number 19. My name is serial number 6, my lord.
Serial number 6.
6, my lord. My case is, my lord, I am not a voter of this particular constituency, the MLA who have issued you a note recommending my name for the transfer, my lord. Firstly, my lord, I'm not the author of that very particular constituency, my lord. And secondly, my lord, the administrative control where I'm working at this point of time, my lord, it doesn't falls under the jurisdiction of the private respondent again, my lord. The concerned MLA who is issued recommending my name, my lord. That is my case, my lord. Therefore,
All under his jurisdiction.
my lord, yes, my lord. I am from 23rd Nacho, my lord. I am from 23rd Nacho MLA constituency, my lord. And this private respondent, the concerned MLA who issued you a note, is from 24th constituency, Daporjo, my lord. And
You're from?
I am from 23rd constituency, Nacho, my lord. And my administrative control also falls under that very particular constituency, my lord. And my lord, this impugn order, the aggrieved party have come before my this honorable court, and their transfer has been, my lord. This court has already protected, my lord, the party who already come before this honorable court, my lord. This is, my lord, for reference, my lord.
So you agree on that even note?
My lord, my lord.
Otherwise, since when you are being posted there?
My lord,
That-
posted, that is also, my lord, I posted there July 24, my lord. July 24, my lord. Recently, I have been posted. Yes, my lord. And my lord, based on this very, my lord, this,
You've made a representation also.
yes, my lord. That is annexation number 3, my lord. Is number 20. And similar situation matter, my lord, this aggrieved party who has come before this honorable court, they all had been protected by this court, my lord. So, my lord, I may be also protected, my lord, for till returnable death, my lord.
So in person to that transfer order, have you been already released from that?
No, my lord, not yet been released, my lord.
Release order is
No,
not yet
not yet
released.
released, my lord.
And in your place, whether any relief?
No reliever is here, my lord.
Yes.
My lord, we'll file the counter.
Till then, it can be stayed.
My lord, he'll return over.
They will. You are Mr.
El Kurdu, my lord.
El Kudi.
El Kurdu.
Have Mr. El Kudi, the Learning Council for the Education. And also have Mr. T. Tarum, the Learning Council Education Department. You are representing respondent number?
My lord, 1, 2, 5.
1, 2, 3 also?
Yes, my lord.
1, 2, 3, 4, and 5.
Yes, ma'am.
1, 2, 3, 4, and 5. Mr. Issue notice to the respondent. Private respondent number 6. However, the formal notice is required to be served on respondent number 1, 2, 3, 4, and 5. And the requisite copy may be supplied to the respondent number 1 to 5 during the course of the. Next. Mr. Anchor to submit it in this regard that the present application has been filed under Article 226 of the Constitution of India against a temple common order of transfer number EED capital letter 10212 11/8 says 22024 dated 24/9/2024 whereby thereby transferring the petitioner from Upper Primary School Bogia, Siam Block under DDSE Taporiju, Upper Subansiri District to the Sri SHIC Yomi District, Arunachal Pradesh, postal. It is submitted by him that his transfer order was passed by the authority and department concerned only on the UN note made by the private respondent number 6, the MLA of from 24 Daporiju ST Assembly constituency, though the present petitioner falls under 23 constituency and the respondent number 6 has no jurisdiction to file any UN note in this regard. More so, he submitted that he was posted in his present place of posting on when you have seen
July, my lord, July 24.
July 2024, and without any basis and without any valid reason, the transfer order was made only considering the UN note of the respondent number 6. Accordingly, Mr. Urdu has prayed for stay of the impugn transfer order dated 24/9/2024 till the disposal of the present petition. First, Mr. Tagum, the learned standing counsel, Education Department submitted that till returnable date the order may be stayed, and in the meantime he will be allowed to take instructions from his department concerned. You take instruction, by the way.
My lord.
By that time you may take instruction from your department and
Well.
if you. Next part. This the matter accordingly after 4 weeks until returnable date, the order, even order that is so and so be stayed.
If you wish.
Wait, please. Wait, please.
Yes.
One of the petitioners are inspectors of the Arunachal Pradesh Civil Police. Your lordship may kindly have page 23. This is the recruitment rule. We are concerned with the promotional post of Arunachal Pradesh Police Service entry grade. Entry grade. Page 23 is the recruitment rules. Rule 3, my lord. We are concerned with B, sub-rule B, Deputy Superintendent of Police and Assistant Commandant, Armed Battalion. So, then my lord will have page 24, rule 5. Method of recruitment. A, 50% of the substantive vacancies which occur from time to time in the authorized permanent strength of the service, my lord, shall be filled up by direct recruitment in the manner specified in such and such. And the remaining such substantive vacancies shall be filled up by merit cum seniority on the basis with due regard to seniority in the manner specified in such and such from amongst officers who are substantively born on the cadre of Inspector of Police employed in the state of Arunachal Pradesh. So 50% by direct recruitment, 50% from the cadre of inspectors. At that point of time only, there was 2 Deputy Superintendent of Police and the Assistant Commandant Arunachal Armed Police Battalion. Now this rule, my lord, came to be amended, my lord. My lord, will kindly have page 31. There was some confusion earlier how these proposals were to be made. Page 31 is the amendment, my lord.
Yes.
Yes. My lord will see that section, my lord, great slate post, as my lord found it, my lord.
Yes.
The great slash post, my lord, there's a column there, my lord. Yes. So rule serial number 4. Arunachal Pradesh Police Service entry grade, subdivision officer / deputy superintendent of police. This is in respect of, my lord, the civil police. And my lord, / assistant commandant, Arunachal Armed Police Battalion. And another grade, my lord, assistant commandant, IRBN, Indian Reserve Police Battalion, my lord. Now, my lord, we'll see how they are to be promoted at page 32, rule 4. Rule 4, sub-rule 4. Arunachal Pradesh Police Service entry grade, post of sub-divisional police officer and deputy superintendent of police. These two posts comprises the, my lord, promotional post of civil police, my lord. / assistant commandant, Arunachal Pradesh Armed Police Battalion, assistant commandant, IRBN, shall be filled up by promotion from amongst the eligible officers belonging to the respective feeder cadre, that is post of inspector of police civil and APBN, IRBN. Meaning thereby, my lord, the post of superintendent of police and DSP, my lord, will be filled up by the feeder cadre of inspector of the civil police. Assistant commandant APBN will be filled up by the inspector APBN and assistant commandant IRBN by likewise, my lord. Now, my lord, will kindly have page 36. This is the requisition sent by the Assistant Inspector General of Police to the Arunachal Pradesh Public Service Commission. So to the Under Secretary Home, my lord. This is requisition for filling up of 4 posts. Serial number 1 has my lord got it. Serial number 1. APPS entry grade, 4 posts. 4. Then, my lord, will kindly have the next page. This is another requisition for filling up for that through direct recruitment through Public Service Commission. Serial number 1, Deputy Superintendent of Police, APPS entry grade, unit civil police. 2 posts. Total 6 posts. They have sent it for recruitment through the Arunachal Pradesh Public Service Commission, direct recruitment. Now, my lord, we'll see page 38. This is an information furnished to one of the inspectors, my lord, under the RTI Act. I will take your lordship directly to page 41. This is under the RTI Act. Yes, my lord, got it. The last paragraph, my lord. As per Arunachal Pradesh Police Service Rule 2023 and recent creation of DIGP Itanagar Police Range, out of 105 APS entry grade sanction posts, 60 posts are for civil police. 12 for APBN, 33 posts IRBN. The unit-wise field and vacant status for promotion quota and direct quota are as under. My lord, will kindly see civil police. Promotion quota 30, 50-50, my lord. Filled up only 21. Vacancy 9. Then, my lord, will see direct quota. 30 again, 50-50 out of 60 posts. Filled up 32, 2 excess. 2 excess. Now, despite there being 2 excess recruitment under the direct recruit quota, we have 9 vacancies. Page 43, in terms of the 2 requisitions sent, my lord, 6 posts of Arunachal Pradesh Police Service entry grade has been advertised, my lord. How can that be done? Law is clear, my lord. If there is a ratio laid down that has to be maintained, it is their own information furnished that 2 already excess recruitment has been done. Now they are going for 8 excess recruitment, taking away all our promotional posts. This is clearly impermissible, my lord. I will rely on one judgment, my lord. Ratio has to be maintained at all point of time, my lord. 1988 Supply SCC 225. Yeah, no. Correct. I'm sorry, my lord, supply list of books earlier, my lord.
We get it in which para you want to? Para
2
number-
and 5.
Para number 2 and 5.
2 and 5. It's clear, my lord, that one says, because these are under rules are under 309 of the Constitution of India. Once the ratio is prescribed, you cannot go beyond that. Consideration by right to consideration, my lord, is a fundamental right. Shall I read, my lord, slowly?
Yes, yes.
I will read only 5 at this point. Reopening the question of interstate seniority on the basis of non-enforcement of the rules from the very beginning may create hardship, and that would be difficult to mitigate, but we see no justification as to why the benefit of the scheme under the rules should not be made available to direct recruits at least from 1982. My lord will note this. When the state government by rules duly framed prescribed the method of recruitment and put the scheme into operation, it had the obligation to comply with it. The explanation offered by the state government for non-compliance with the requirement of the rules does not at all impress us. We therefore direct that as on December 9, the state government must ascertain the exact substantive vacancies in the category assistant engineers in the service. On the basis of that, 37.5% of such vacancies were to be filled up by direct recruitment. The position should be worked out. That was the prescription. Promotees should be confined to 62.5% of the substantive vacancies, and in regard to 37.5% vacancies, the shortfall should be filled up by direct recruitment. In that case, there were excess promotion, my lord. So what I am praying for, my lord, at this stage is let notice go, my lord. And in respect of this 6th post of my lord, Arunachal Pradesh Police Service advertisement at page 43, this may be a statement. Has to be, my lord. Because otherwise this will create confusions for the candidates also. Because ultimately, if your lordship holds, your lordship has seen the document furnished under RTI. There's excess recruitment, direct recruit quota, already 2, now 6. That is not permissible. Law is clear on that. If this is allowed to remain, it will create confusion for the candidates also. Let them file their affidavit as early as possible. This can be sorted out. Otherwise, law is clear.
Yes, Mr. Ed.
Lordship, matter may fix on Lordship 9. Sorry, November 11. Okay. Then 7 November. November 11. Exam. December 12. Okay. Last part of this month. On 22nd.
No, what
This
about the
ultimate-
break for stay of that?
Until then, Lordship, it can be Lordship.
State.
Because examination
Has to be, my
in
lord.
December, Lordship. So my only Lordship request, Lordship, if matter can be disposed of before Lordship.
Yes, if they file their affidavit, it can be disposed of. It is up to them.
Lordship, this exam will be conducted in the month of December. So not only DSP.
No, we are only
all-
praying in respect of DSP.
No. Now for that also, merits are to be, options are there. So that will be inconvenient for APPSC to conduct the exam. And to reschedule any exam is very tough. So therefore, we'll file.
No, whether this on the prospective death notification, that advertisement, whether any date has been fixed for.
Yes, already the date is fixed.
Date is fixed.
That is DSP exam will be conducted along with the civil service,
15th of December.
15th of December.
Minority state is
So-
let them come under affidavit before that.
So-
It is not a question of hardship of the APPSC. It's a question of law.
APPSC has nothing to do
It's a question
because
of law.
that's
If
for
it
the
is a-
government.
If it
That's
is
for the government.
excess, my lord, that is not permissible. It is for the government, my lord, to clarify that. Public Service Commission is a recruiting authority, nothing more than that.
Yes. We are close.
The matter will fix on 22nd, Lordship,
Yes.
without staying the Lordship, the embassy.
Minority state is apparently illegal, my lord.
Because even if this is not granted also, Lordship, they are not going to pay you. Because examination is in the month of December. Lordship. So therefore, on 22nd, letter will still also. Till then, before that, we will be filing our affidavit. The matter can dispose on that day.
And you want to say that if this is stayed, then one date has already been fixed on 15 December.
Yes, Lordship.
So prior to that, it can.
We are asking.
Yes.
Prior to date. November this 32nd.
This will in fact create more problems, my lord. Apparently, it's illegal. If your lordship finds that the RTA informations are correct, your lordship will obviously interfere with. Law is settled on that. So, these candidates who are opting for DSP, APPSC, they will be in trouble. They should be clear about this. They should know it. So, this is the position. Because once your lordship holds that this is excess, your lordship will obviously take it out from the advertisement. No post of DSP will remain.
On 22nd,
Cannot.
then interim part can be considered on 22nd also. If it could not be concluded on that day also. The interim can be considered also. That observation, the matter can be decided on 22nd.
That can
No, otherwise the date is fixed on 15th of December.
be December.
No, but whatever, 15th of December means, so okay, then at least minimum 20 days they will get.
No.
But as from your submission, it is seen that there's excess post already.
Then
two
part,
years
They are document.
then part also we need to take this.
What more instructions, my lord, it is the RTI document. But
22nd
signed by my learned friend is saying the superintendent of police is wrong.
Yeah. Because examination is in demonstration also. That part.
This is signed by the superintendent of police.
Observation is made on 22nd interim because in case we do not file our affidavit.
No, but this is a case. If my learned friends are, if your lordship passes an entry order, my lord, I am sure, my lord, they will file their affidavit and it can be disposed of on the next day. If not, my lord, it will not. Hampering each and every candidate as well as the petitioners, my lord, whose right to be considered for promotion has been infringed. It's a fundamental right.
Therefore, also I am barely submitting.
No, but the one
Observation
question may
is
be
made.
there. Obviously, you're saying that if stay is dead, then they will file their affidavit in
Yes.
position and matter may be disposed of.
Yes.
Suppose on that day, if you have some difficulty in all, if matter remain there, then they will face a difficulty in
This
conducting
is,
the, that is.
but prima facie, your lordship has seen, if it is not permissible, it is not permissible.
No, it's okay. It's not permissible, it's not permissible. For that, if they take instructions on 22nd, if it is fixed, then obviously it will help most probably. Otherwise, no, otherwise what I'm saying, the suppose stay is there. And on that day, if matter could not be heard, but due to any reason for your problem or my problem. In that case, the requisition, I mean, the date is fixed on 15th of December.
Oh.
That will again may create some problem. That is the issue only.
Supposing, I put it another way, man, supposing this matter is not able to be heard before 15th of December, for some reason or the other, I am ready. My petition is here. If affidavit doesn't come, then, my lord, the candidates will be appearing for an examination for which they just cannot appear, my lord. What will happen then, my lord? It will create all the more problems. There are only 6 posts. Apparently, these 6 posts cannot go.
Okay, then we do one thing. We may pass a state and matter may be fixed on 22nd. then.
Yes.
That will be on 22nd. And that in that case, we'll be in trouble. We will file affidavit in opposition within 22nd. Then matter may be disposed of.
Otherwise, even stay is granted also, Lord, because online application is only being receiving.
That is.
That part also it is not going to be stopped. So automatically they will be filing. Lord. So they are not going to prejudice if it's reconsidered on 22nd. Lord. So petition is not going to prejudice. Lord. So that's only law.
Because
Otherwise,
online-
staying will have some sort of implication. Lord. So therefore, I am clearly submitting law on 22nd. It can be considered interim.
Come to me, I'll pass you. We can we've considered the interim on 22nd. Because obviously there are some forms are still, I mean, online forms are still filling up. It may create another problem. But obviously he is saying that you
I
take
know,
instruction.
the difficulty, I don't understand this, my lord. My lord was saying, people, it doesn't, once your lordship is, where is the question of receiving any more online applications, my lord? Your lordship stays this.
Then in that case also that may be one problem it may be there because 15th of December date has already been fixed. Whether it is conducted or not conducted, that part will come later.
That will be all the more
In that
difficult,
case,
my lord.
Suppose if the candidate wants to file his application form.
Yes.
So stay may hamper in
So,
that manner.
my lord will think of a situation, my lord. Applications are filed, filled up for the post, they give options for this APPSC post,
Yes.
police service post. And your lordship ultimately holds that this post could not have been advertised then. With prima facie I have shown they could not have done it.
Just now I have been informed also, this 10th is the lawsuit, last date of submission was. By now, lawsuit, many applications would have been already submitted.
That is immaterial, my lord. My lord, I have shown my case, my
Which has
lord.
already been submitted, it's okay. That will be, but his question is that if
But
examination
the
is.
situation is almost same lawsuit, because many have been already submitted lawsuit.
Why are we not
If-
arguing on law, my lord?
Therefore, also, I'm only praying for 22nd lawsuit, whether maybe dispose of on that day lawsuit. If not possible, then it can be granted. I'm not going to object also on merit if it's still lawsuit.
Okay, I'll pass you out. Okay.
My lord will then reflect that, my lord, that on 22nd, if the
Yes,
matter
yes,
is not
obviously,
disposed of, then the
obviously.
interim order will
Reflection will be there.
Yes.
I just want to say one thing that I have already instructed him. We have some election matters. Those have been pending since long because I was in Guwahati Division Bench, so there was some difficulty picking up those matters. So at two, most probably first priority will be given those election matters, then the other matters will come. Because these are, I could not take it from Guwahati, in fact, online. So that may create one problem. So let us fix that matter and thereafter we'll take the other matters.
My lord, in item number 19 and 21, the state is to file affidavits. In 20, they have filed, of course, we would like to take some instructions. And on 19 and 21, the state has to file an affidavit.
19 and 21.
19, 21 and 22, both are 2024 case, my lord. So. we do request
19,
of-
21 and 22. You have to
Right.
file affidavit.
Affidavit, yes.
So 19,
19,
21,
21 and 22.
19 to 22.
no,
19,
no,
20,
19 to 22. In
Right.
19, 21, 22, you have to file affidavit.
Yes, we have to file the affidavit.
And in 20, most
20, we have
filed.
already filed.
there we have to give a reply
In 20.
in 20.
In Hiribo, 19, 21, 22, government to Vindunasi. 19, 21, 22, you are representing 1, 2, any respondent numbers?
Respondent number.
Okay, we'll sort out, we'll take up. And 20, you are, 19, 21, you are also appearing for, all these items?
Yes, madam. My lord may reflect the additional AG and the standing council land.
Yes.
That way, it will, instead of the respondent.
Tanaka Kolga Habu, representing this so and so. And 20, you are you want to file your rejoinder. 22 rejoinder. Just maybe, yes, where it can be fixed.
16 December, because they will also take some time, we'll also. Yes,
Well,
if it is
16
not-
December, madam, yes.
if it is not inconvenient to lodge. 16 December.
December onwards, 1920. Okay, we'll fix it.
My lord. Well, in item number 16, my lord, there, one, impleading petition has been filed. My lord, this matter pertains to the Namdafa Reserve Forest. It was of 1960s and all, 60s, 70s around that time. So there also, my lord, some time would be required because we are in the process of collecting the documents since they pertain to a long back period. So, my lord, could that also be fixed on 16 December? One of the state is there.
I has been filed by you for your improvement.
On the consent of parties, madam.
So 16 on December will do?
Yes.
And the request made by this so and so and so. 16 December, all the matters. Who wants time? He.
My lord, on joint request of the parties.
On joint request. In I also, you want to file any?
Objection, my lord. We are in the process of obtaining instructions. My lord.
Prior to next date, your honor, copies may be started.
Yeah, of course.
Copies.
Objection.
No, copies of?
Of the objection, we'll
No,
definitely,
objection will be first.
definitely will.
But till now, you have not been implemented, I think.
No,
Otherwise, copies of them should be preserved.
Otherwise,
16
registry won't accept it.
16.
16. Deep.
My lord, in that event, item 15, my friend is appearing. This may also be taken off after 2 weeks, ma'am.
Item number 15.
15, I am for the state under petitioner, appellant,
So you're for the appellant,
appellant.
I am for the respondent.
denier for the respondent. So here, what is the stage of the case? You have already filed your affidavit?
My lord, it is for hearing. It's an appeal, my lord, arbitration appeal
Okay.
from the
anyway,
interim order.
It's a case of hearing only now. Admission
Hearing.
in admission.
Admission, it can be disposed. In fact, it has become subject to what my learned friend submits.
Okay. Anyway, okay.
After 2 weeks.
That is also you want on 16th?
No, that may
Because-
be earlier, my lord.
Earlier.
But after 2 weeks.
After 2 weeks.
After 2 weeks. The joint request after 2 weeks. So it will be listed in admission column only?
Admission. Deep.
Lordship, may I beg to mention item number 29?
20?
29.
Yes, 29.
This matter may be fixed after 2 weeks.
You have
I
any
have
from the
taken
other
consent
side?
from the staff here.
Yes, I am for the respondent.
With the consent of the other side. Connect counsel for the petition, Mr. T. Tupper, it's prayed for an adjournment. Just a matter. After 2 weeks will do or after 2 weeks?
2 weeks. Interim order is there, that may be continued.
Interim order was there?
Yes, continue.
Interim order be continued till next set of questions.
My lord, I beg to mention, my lord, in item number 31, election petition, my lord, this morning I filed one IA application for adjournment. My lord, it seems that this has not yet come. My lord, my lord may call for from the registry. My lord. IA
Not yet come.
has not yet come. This may be called for. My lord. It's for adjournment only. Deeply. Yes.
But Mr. Tagore, my question is that I'm supposed to take the election matter 31, 30, 31, 32.
31, my lord, 31.
Your number is 31.
Yes, my lord. Here, my lord, I filed the adjournment application, my lord, raising certain objection, maintainability, my lord. So we, because of some shortage of the document, we could not file today, my lord. Within this week, we'll be filing our appropriate application, my lord, on obtaining certified copy. And that's why, my lord, adjournment short for, my lord. Within this week, we'll file, my lord. That's why, my lord.
Okay, we are calling you.
My lord, deeply.
May I please, ma'am? My lord, I beg to mention item number 17 and 18.
17 and 18, yes.
Matter may be taken up on 12, ma'am.
So you're for the petitioner side?
I am for the respondent, ma'am.
Respondent number?
1 and 2. Ma'am.
Who is for the petitioner?
I am for the petitioner, ma'am. In item number 17, I am for the petitioner.
The 17 and 18.
18.
You are for 18,
it's an analogous matter.
Okay. So you want on 12th?
Yes, ma'am.
12th of this month?
Yes, 12 of this month, ma'am.
We are listing it on 12th.
Interim order is there, my lord. Interim will continue.
Interim.
Yes,
For both the petitions, interim is there?
yes, lordship.
In your case also? Interim?
Yes, lordship.
The consent of the other side, so interim will be continued till next set of questions. So we are listing it on 12th.
All right, all right, all right.
Get here. Actually, you get it. You don't know about me? Then.
Yes, your 2 minutes. Mr. Opara is coming.
So you're for the respondent,
I'm for the private respondent, my lord.
private respondent
The-
number 3,
Three, my lord. And the allegation of the petitioner is that,
and you're for?
no, with me, ma'am.
Oh, okay,
My
okay.
lord. And the allegation of the petitioner is that without completion of his tenure as per the transfer policy, he has been transferred. That is his sole allegation in the petition. I would be on, my lord, I would be on, my lord, that the transfer policy does not confer any rights. Yes, he has come, my lord.
Oh, that means in his place, most probably you are being, you are being posted here.
I have been, and in fact, I have joined, my lord.
Yes.
I'm sorry, my lord. I thought my lord will be taking a balancing petition, my lord.
No, this last motion was there, that's why we have taken this one.
My lord. My lord, I am challenging the impugn transfer order, my lord, which my lord will find at page 22, my lord.
Yes. Page 22.
Yes, my lord. My lord, by this order, my lord, the private respondent, he has been transferred in my place, my lord. My lord will find that no transfer.
Yes.
My lord will find that no posting order has been issued to me, my lord. Only the private respondent will be transferred in my place, my lord. But I was not allotted any posting place, my lord. By this order.
Not allotted.
Not allotted, my lord. By this order, my lord. This order is of 22nd October 2024, my lord.
Hmm.
The next page, my lord. Page 23, my lord.
Yes.
Consequent upon the earlier order, my lord, the order dated 22 October 2024, my lord. This order, it is 25th October 2024, but it has been signed on 28. Here, my lord, I have been transferred from my present place of posting, which is Executive Engineer Trujillo Division, to the Office of the Chief Engineer, PW Western John, Itanagar, my lord. So I am challenging both these impugn orders, my lord.
Why? What is the reason?
My lord,
Why we are challenging this one?
my lord. The next page, my lord, my lord turns to page 24, my lord.
Hmm.
My lord, see the date, my lord. It is 17 January 2024, my lord. This was the order by which I was transferred to Trujillo, my lord.
Hmm.
17 January 2024, my lord. Meaning thereby, my lord, I have hardly completed only 9 months in my present place of posting, my lord. I have not completed my tenure, my lord, which is normally 2 years, my lord, as per the guidelines, my lord. Now, page 25 is the representation which I filed before the Principal Secretary, PWD. It my lord turns to page 26, which is the guidelines, my lord. It was issued on 18th August 2021, my lord. May I read it, my lord? Page 26. In inviting a reference to the government order that is so and so, an amended order thereof, so and so dated, regarding policy guidelines on transparent posting of all categories of officers and staff under the government of Arunachal Pradesh, it has been observed that departments are not following the guideline surreptitiously. Hence, the aforesaid transfer posting policy guidelines are reiterated for strict compliance of all departments. Further, it is hereby clarified that in terms of the guidelines under reference, the normal tenure of posting for all categories of officers and staff is 2 years, my lord. If my lord sees the language which has been used, my lord,
are not following the guidelines seriously. Hence, the aforesaid transfer posting policy guidelines are reiterated for strict compliance of all departments, my lord. Meaning, they were, my lord, this has to be strictly followed, my lord. But apart from that, my lord is well aware, my lord. Transparent posting is an incident for service, my lord. At any point in time, I can be transferred. But the sole reason being, my lord, I can be transferred only in public interest of administrative exigencies, my lord. Now, there is a guidelines, my lord, which has been issued by the government. Now, in the host to that guidelines, my lord, in violation of that guidelines, my lord, I have been transferred out. And in my place, somebody has been brought. And they say, as for the transfer, the impugners, my lord, I was transferred out on public interest, my lord. My only case is that, my lord, what was the exigency or what was the public exigency or administrative exigency or the public interest which necessitated the government to transfer me out, my lord. I allege, my lord, there is malafide. There was no any public exigency, my lord. And my lord may kindly appreciate, my lord. Page 27, my lord. This is a representation which has been issued by the Jilla Parishad members, 3 of them from the constituency, which whereby they have requested the principal secretary to retain me in the present place of posting, my lord, for public interest, my lord.
So what about the representation, whether it has been disposed?
No, not yet disposed, my lord. And my lord, also kindly consider that, my lord, now I'm 58.5 years, my lord. I'm almost retiring, my lord. I was inducted to the government servant on 25th of May 1989, my lord. I put in around 35 years of service, my lord. Now I'm retiring, my lord. And I don't have any blemish on my service career, my lord. And it is verge of retirement, my lord, I have been posted out. That too in the horse of the guidelines. Therefore, my lord, in my humble submission, my lord.
So what is the present position? Have you been released order has already been there?
No, my lord, I have not been released. But I don't have any instruction of the private respondent, my lord. My only contention is that, my lord, if I have been transferred out in public interest, as they say, my lord, as the government says, my lord may kindly call for the reports, my lord. And my lord may kindly, and let them kindly explain as to what was the necessity or the public exigency which prompted them to transfer me out. And in the meantime, the impunity will be stayed, my lord. That is my only humble prayer. Obligation.
My lord may come to the page 22, the order which is impugned.
Yes.
In the interest of public service, the governor of Arunachal Pradesh is pleased to order the posting of Sri Neelam Mama, newly promoted to the post of executive engineer, as executive engineer, Tricino PWD division against Sri so-and-so with immediate effect. Now, my lord, consequent to my promotion, I need to be posted in a promoted post. That was the reason why I have been, to my understanding, my lord, that is the reason to give effect to my promotion, I have been posted in this place. Now, I have joined, my lord, I have joined on 29. And it's an ex parte joining, my lord, on 29th of October. On the basis of the OM, my lord, I reported before the superiors. They said you take over charge. In
So
paragraph,
when you have joined?
my lord, on 29th of October. That is my joining report, my lord. And I am functioning as the executive engineer in Tricino PWD division. This is on the strength
But
of
as
the.
per him, it's a release order is not been issued again for him.
My lord, my lord may come to the OM. That
Yes.
one page, my lord, clause 4. In case where the relieved officer does not hand over charge to the relieving officer when he comes to join, the relieving officer will assume charge of the office unilaterally ex parte so as to implement the government order and to enable the officer to discharge his duties and responsibilities, so and so on. On the strength of this, and my lord, I am backed by certain decisions. I would like to place those, my lord. Sorry. 154. My lord, the Supreme Court is very clear. In orders of transfer, they cannot first file the case here. My lord may come to my lord, 2006 9 SCC 583. It's given in the order. It's given in the order itself. My lord. I mean, in the order of the decisions I'm relying on. 2006, my lord, 9 SCC 583. My lord may come to para 6. My lord, we have perused the record with the help of the learned counsel of the. My lord finds that. Yes. And we find that no case for interference whatsoever has been made out. In the first place, a government servant cannot disobey a transfer order by not reporting at the place of posting and then go to court to ventilate his grievances. It is his duty to first report for work there where he is transferred and make a representation as to what may be his personal problems. The tendency of not reporting at the place of posting and indulging in litigation needs to be curbed. My lord, this was followed in other cases by this High Court as well, including, I have not bothered lordship with those cases, but the first requirement is he has to go to his place of posting, join there, submit a representation, and after that only approach the court. This is what has been the guiding principle behind transfer posting cases. Now, my lord may come to the second one, my lord, 1993 4 SCC 357. This is Union of India versus SL Abbas. My lord may come to para 6 and para 7. I'm relying on 6 and 7. What my friend is relying on is that the transfer policy lays down a period of 2 years for normal posting. The keyword here is normal. So he's banking on the transfer policy. Now, what does the Supreme Court say on this, my lord? In SL Abbas, the Supreme Court is clear. If I may read para 6, my lord. Para 6. An order of transfer is an incident of government service. Fundamental Rule 11 says that the whole time a government servant is at the disposal of the government, which pays him, and he may be employed in any manner required by the proper authority. Fundamental Rule 15 says the president may transfer a government servant from one post to another. That the respondent is liable to transfer anywhere in India is not in dispute. It is not a case of the respondent that the order of his transfer is vitiated by mala fides on part of the authority making the order, though the tribunal does say so and so. My lord may come to the last sentence of this para 6. Para 6, the last sentence, starting with he relies. He relies on certain executive instructions issued by the government in that behalf. Those instructions are in the nature of guidelines. They do not have statutory force. Who should be transferred where is a matter of appropriate authority to decide. Unless the transfer is vitiated by mala fides or made in violation of statutory provisions, the court cannot interfere with it. While ordering transfer, it is no doubt the authority must keep in mind the guidelines issued by the government on the subject. Similarly, if a person makes a representation with respect to his transfer, the appropriate authority must consider the same, having regard to the exigencies of administration. The guidelines say that as far as possible, husband and wife, this was on spousal posting, may be posted at the same place. The said guideline, however, does not confer the government employee with a legally enforceable right. So in this case also, my lord, the petitioner does not have a legal enforceable right. Then now my lord may come to 2004 11 SCC 402. This is Govardhan Lal. It has been held in many cases, my lord. Here, my lord may directly come to para 7. My lord finds 2004 11 SCC. My lord. Para 7, my lord. It is too late in the day for any government servant to contend that once appointed or posted at a particular place or position, he should continue in such place or position as long as he desires. Transfer of an employee is not only an incident inherent in the terms of appointment, but also implicit as an essential condition of service in the absence of any specific indication to the contrary. in the law governing conditions of service, unless the order of transfer is shown to be an outcome of mala fide exercise of power or violative of or any statutory provision, an act or rule. What is statutory provision? The Supreme Court clearly says it has to be an act or a rule, or passed by an authority not competent to do so. An order of transfer cannot be lightly interfered with as a matter of course or routine for any or every type of grievance sought to be made. Even administrative guidelines for regulating transfers or containing transfer policies may at best afford an opportunity to the officer or servant concerned to approach the higher authorities for redress, but cannot have the consequence of depriving or denying the competent authority to transfer a particular officer or servant to any place in public interest as it is found necessitated by exigencies of service, as long as the official status is not adversely affected and there is no infraction of any career prospects such as seniority, scale of pay, and secured emoluments. My lord, here he is posted in his same position as executive engineer. I have been promoted, so I have been posted as an executive engineer. In his case, there is no allegation of mala fide in the writ petition. I have gone through the writ petition, my lord. No allegation of mala fide. And if there is any allegation of mala fide, he should have made those persons against whom he is alleging mala fide as persons, respondents in person, my lord. There is no other private respondent. So there is only a submission that it is accentuated by mala fide. What is the mala fide? There is no pleading to that effect. And the submission of my learned friend, I'm sorry to say, my lord, is beyond pleadings. Insofar as mala fide is concerned, there is not even a whisper. So therefore, in para 7, continuing, my lord, the court has often reiterated that order of transfer may be made even in transgression of administrative guidelines, cannot also be interfered with, as they do not confer any legally enforceable right, unless as noticed supra, shown to be vitiated by mala fides or in violation of statutory provisions. So this is what the Supreme Court says. And there are decisions of our High Court, and as well as one very recent decision of the Honorable Supreme Court, my lord, in 2024 SCC Online 279. This is from Arunachal itself, my lord, Pubi Lombi. My lord, may come to para 15, my lord. The Supreme Court summarizes, my lord. Para 15. In view of the foregoing enunciation of law, I'm not bothering lordships with the other discussions on the previous judgments. In view of the foregoing enunciation of law by judicial decisions of this court, it is clear that in the absence of, number 1, pleadings regarding mala fide, absent in this case. Number 2, non-joinder of the person against whom allegations are made, transfer being, 3, violation of any statutory provision. 4, the allegation of the transfer being detrimental to the employee who is holding a transferable post. Judicial interference is not warranted. In a sequel of the above settled norms, the scope of judicial review is not permissible by courts in exercise of jurisdiction under Article 226 of the Constitution of India. All those 4 conditions given for the Honorable High Court to exercise or interference under Article 226, all of them are missing in this case. There is no allegation of mala, as I have already submitted, my lord. These 4 criteria are not there. Then, my lord, para 18, once again, it's just another, just one line. In view of the stand taken by the government in the absence of plea of mala fide and no averment regarding violation of statutory provision taken by the private respondent before the High Court, interference made by the division bench, setting aside the well-reasoned judgment of the single judge, is not justified. So, my lord, these are the Supreme Court judgments. And another division bench of our High Court, my lord, 2024 SCC Online, Guwahati 152. My lord, may come to para 18. Our division bench, my lord. Towards the bottom of the page, man. From the above decisions of the Honorable Supreme Court, it is settled that a transfer of a government employee cannot be interfered with solely on the ground that the same is in violation of the transfer policy. That is the petitioner's sole ground, which, in my humble submission, in light of the judgments of the Honorable Supreme Court, as well as the division bench of our High Court, my lord, it is not permissible to interfere. And there was another judgment of a single bench. I'm not bothering lordship with that, but it's the same, my lord. That's 2019 2 GLR 577. Here also it is the same conditions which are reiterated. So in my humble submission, my lord, since The only allegation is that of his normal tenure not being over. That cannot be a ground for interference. So there cannot be a stay. Secondly, my lord, I have already joined. I have taken over charge. So in the light of the office memorandum, I am discharging the duties of the executive engineer there. It is a promotional post. So there cannot be a question of stay in my humble submission, because if there is a stay, I do not have a post to go back. Because earlier I was not an executive engineer. This is a promotional post. Since I have joined now, staying that would revert me to a junior post, which is impermissible. But in case of the petitioner, he is posted in the office of the chief engineer here at Itanagar. It's a good place of posting. So my lord, he will not suffer any difficulty.
My lord, it's a very surreptical submission, I would say. If he doesn't have a post, my lord, why not? Why he was posted to my place where I have been posted now, my lord? If there was no post, he could have been posted in Itanagar. Why me, my lord? Why in my place of posting, my lord? Yes, my lord, I agree, my lord. The interference of the judicial review in transparent posting cases are very scanty, my lord, and seldom it has to be refrained, my lord. However, my lord, when there is a guidelines on there is policy guidelines, my lord, which says that it has to be strictly followed, my lord. It has to be violated or any order deholds that guidelines has to be done only on public interest, my lord, public exigency, administrative exigency, my lord. My humble submission is that, my lord, let the respondents show, my lord, that I was posted out or that person was brought in on public exigency, my lord. That is only my case, my lord. Since my elder brother has shown some judgments, but only one small judgment which I would like to rely on policy, my lord, the policy guidelines, my lord. 2004, 12 SSC 299, my lord. Para 4, my lord. Right. Yeah. Para 4, my lord. Married. Transfer which is an incidence of service is not to be interfered with by courts, unless it is shown to be clearly arbitrary or visited by malafide or infraction of any prescribed norms or principles governing the transfer. Unless the order of transfer is visited by malafide or is made in violation of operative guidelines, the court cannot interfere with it. Who should be transferred and posted where is a matter for administrative authority to decide. Unless the order of transfer is vitiated by malafide or is made in violation of any operative guidelines or rules, the court should not ordinarily interfere with, my lord. There is only my case, my lord. There is a policy, my lord. I don't think, my lord, the government has framed these guidelines, my lord, just for namesake, my lord. There has to be some force in it, my lord. It has to adhere, my lord, only on exigencies, obviously, my lord. I do admit, my lord, on public interest.
Yes, Mr.
Therefore, my lord.
Matter is fixed on lawsuit Friday. I'll produce reports. What is the lawsuit administrative agency? On what ground lawsuit is transfer order execution? If Friday. Monday. Okay, then Monday I think is my friend is come from Guwahati, so
Monday also matters have been fixed, I think. No? Monday our billing address will be fixed. Yes. 11, what's the day? Maybe the matters have been fixed on Monday. Friday it will be. You have any problem Friday?
I've
You're
leaving
leaving.
the eyes on my.
In regards to stay of the order, what do you want to say?
This order may be stayed. Since it is a very short date, my lord, and my lord is well aware, my lord, in transparent posting, my lord, since I need to join your, my lord, and then I may be released, but still now I have not been released, my lord. But if it is lengthy, my lord, I will surely be released, my lord. Till that period, my lord.
My lord, I have already joined, my lord. There
I have
cannot be two persons in
but
the
I have
same
not been
post.
released, my lord.
But there's no question of release, and mine is a promotional post. I cannot go back to my old post. So I have to be there. And my lord, SL Saxena is clear, my lord. Before challenging, he has to join in his transferred post, and thereafter only he can challenge.
The moment I joined,
It will be in violation of Saxena, my lord, the 1993, which the first judgment which Lordship did. So there cannot be a stay, my lord.
The other matters, so. Why you want to fix it on Friday or Monday?
Friday or Monday, any day. Tuesday, and no issue.
Tuesday I cannot fix.
to call for the reports, my lord.
Huh?
Since they say I've been transferred on public exigency, my lord, let them, so, my lord, bring for the report. I'm alleging that there is no any public interest involved or the innocent exigencies in transferring me, my lord. I'm alleging that, my lord.
That the government knows, my lord.
Let the government
is for
produce
the
the report and show that it was a public exigency. I said, no, there is no public exigency. It is a violation of all the rules and there is malafide. Let them call for the records, my lord. We'll see then, my lord. And till then, my lord, I may be, it may be straight, my lord, suspended. This is my humble prayer.
The learned counsel for the petition. And also had Mr. Astropin, the learned senior, Advocate, representing the state respondent. And had Mr. P.D. Nair, the learned counsel, appearing for the private respondent number. Private respondent number 3. It's an application under 226 of the Constitution of India, whereby the legality and validity of the employment transfer order, white memo number 11011 bracket of 2011/4 of the 2021 establishment ESST OPWD/112-29 dated 22/10/2024, whereby the petitioner has been transferred from executive engineer from the Trigino PWD division with immediate effect. Issue notice. As the respondents has already appeared and accepted notice, no formal notice is required to be issued. However, a copy of the requisite copy of the petition be served in regular course of the Mr. Pada, the learned counsel for the petitioner, submitted in this regard that the transfer order dated 22/10/2024 has been passed, whereby the present petitioner was transferred and posted in the office of the executive engineer.
My lord, I'm challenging both orders, my lord. One is the 22 October order is, my lord, the order by which the private respondent was transferred to my place, my lord. And 28 October is the order by which I was transferred from Trigino to the office of the chief engineer. Two orders, my lord.
Two orders. Transfer order by which the private respondent number 3 was posted in the place of the present petition, and by order dated 28/10/2024. Where you annex that order?
Annexure
28.
Annexure 1 and 2, my lord. The next page, my lord. Page 23.
Annexure 1 and 2.
Yes, my lord. Page 22 and 23.
Yes. So your place of order is on 25th of October.
It is 25th, my lord, but it has signed on 20.
Signed on 28th.
Yes, my lord. That's why I've written to you.
And the present petitioner was transferred from his present place of posting to the to the executive, to the office of the chief engineer PWD, bracket of WZ, Itanagar, at Itanagar, against the existing vacancy, wide order dated 28/10/2024. It is submitted that he joined in his place of posting. You joined on
17th January, madam.
17 January.
Yes.
17 January 2024, and within 9 months, he was, and after 9 months, he got transferred for so and so by violating the policy, transfer policy of the
18 August 2021, madam.
transfer
Page 20.
policy of 18th August,
26, page 26.
page 26. By violating the circular dated 18th August of 2021 by the department. Wherein it is exclusively mentioned that all categories of the officers and staffs will be transferred, normally transferred within 2 years. But even after, only after 9 months of his posting, he got transfer order, and which is against the rule, and hence it has been challenged by the present petitioner. It is further submitted by Mr. Okada that there is nothing in the order under which public interest of the administrative exigencies, the order has been passed, or the transfer order has been passed against the present petition. Accordingly, he paid for stay of the transfer order till disposal of the present petition. He also cited a decision of Honorable Apex Court reported by 2004 to SCC 299, wherein it has been expressed to view by the Honorable Apex Court that the transfer order should not be interfered with. No, interfered with unless it is shown to be clearly arbitrary or mala fide, but can be interfered if it is in violation of operative guideline or rules of the concerned department. Mr. Dixper, Mr. Tapin, the learned senior government advocate, submitted in this regard that he needs some time to take instructions from the department as to under what public interest or administrative exigencies the order has been passed by the department, by order or transfer has been passed for the present petition. Mr. P.D. Nair, the learned counsel appearing for the private respondent number 3, submitted in this regard that in pursuant to order of the transfer, he already joined in his service and he took the unilateral charge / ex parte on 29 October 2024, and presently he is working from his present place of posting. Mr. Nair further submitted that there was administrative exigencies for his transfer and posting as he got promoted, and after promotion, he was appointed and transferred in the post of the present petition, which is a post of executive engineer after his promotion. If there is any stay in the order, he cannot be revert back to his earlier place of posting, where from he already got promoted to the post of executive engineer. Mr. Nair further relied on some decisions of the Honorable Supreme Court reported at the wherein the Honorable Apex Court has view in case of Saxena, in case of SC Saxena, that Supra, that a government servant cannot disobey the transfer order by not reporting at the place of posting and then go to a court to ventilate his grievances. Full stop. It is his duty to first report for work where he transferred and make representation as to what may be his personal problems. In the other judgments of the Honorable Apex Court also, the guidelines of the department concerned is not legally enforceable and said guideline does not confer upon the government employee any I get you. Submit review that the guideline of the government department does not confer the government employee a legally enforceable right. It is the fundamental rule which says that the president may transfer of a government servant from one post to another, and that cannot be and hence it cannot be legally enforceable in the eye of law. The Honorable the Supreme Court, in case of Kubi Lombi as referred above, as referred, has also held that that in absence of plea of mala fide and no averment regarding the violation of the statutory provision taken by the private respondent before the High Court. No, sorry. So hold that the interference there should not be any interference if in absence of any plea of mala fide or violation of the statutory provision taken by the petition. Citing those the above referred judgment, the Honorable the learned counsel for the petition, the private respondent has submitted that that as per the guideline of the Honorable Apex Court, the government employee cannot be the transfer order of the government employee cannot be interfered with solely on the ground of that the same is in violation of transfer policy. Next, considering the submission made by the learned counsel for both sides, I find it necessary to call for the records from the learned records as to see as to under what public emergent, what public interest or administrative exigencies the order of transfer has been passed. But at this stage, I do not find it prudent to pass any order. Let the matter be listed. When it can be listed, then stay is not there. Stay is not there, so we have to list it early. Monday, lots of matters.
My lord, at least till Monday, my lord.
It's okay. Monday. Take instruction, Mr. Topping, is there any? And now he brought one reason that he got promoted, but another way, Mr. Pada has submitted that Why not, why only in his post? It can be transferred and posted in the office of the chief engineer itself. If not, if, obviously he got promoted, so he has to be appointed in somewhere in his post of posting. But why in his place? That is his question, so let us see.
Homeless.
Deep here.
My pleasure, Lordship. Lordship, as per order dated 29/7/2024, the election petitioner has taken a step upon respondent number 1 to register post on 30th/7/2024 and through Dusty mode on 2nd August 2024. And with regards to respondent number 2, the register post through register post step was taken on 30th/7/2024, and through Dusty it was taken on 3rd 8/2024, Lordship, and accordingly affidavit was filed on 19/8/2024. And as per
Who
this,
filed the affidavit? Number
the
two?
petitioner, Lordship, petitioner
Okay.
has filed the affidavit
Regarding
of Dusty
Dusty.
service, yes,
Okay.
and the matter was supposed to be listed on 21/8/2024. However, due to paucity of time, it was not taken up, Lordship. Now, Lordship, since it has been,
Already appeared, I think.
Lordship,
One has filed his Wakalatnama.
yes, Lordship,
That's one number one.
Lordship.
Yes.
Yes, despite the receipt of Lordship, the service of summon that is on 2nd August 2024. Now it has been over 90 days, Lordship. They are yet to file their written statement. So may I pray that the matter may be proceeded ex parte against the respondent number 1 as well as respondent number 2.
May I please,
The
Your
proper
Lordship?
respondent.
May I please, Your Lordship? I am appearing on behalf of respondent number 1, Your Lordship. We were supposed to file the written objection as of today, but the respondent number 1 is feeling under the weather, so he could not travel all the way from Nari to Itanagar. So we may be allowed some more time to file the written objection, Your Lordship.
Lordship, in that case, they should have come up with certain appropriate application, Lordship, since section 86, subsection 7 of representation of people says that it has to be, a trial has to be conducted as per civil procedure code, Lordship. Now, as per order 8 rule 1, Lordship, may I read order 8 rule 1, Lordship. The dependent written statement, dependent shall, within 30 days from the date of service of summon on him, present a written statement of his defense, provided that where the defendant fails to file the written statement within the said period of 30 days, he shall be allowed to file the same on such other day as may be specified by the court for the reasons to be recorded in writing, but which shall not be later than 90 days from the date of service of summon. Now, in this instant case, the respondent through registered post, the step was taken on 30th. Now, with regards to Dusty service, it was taken on 2nd of August, Lordship. Now, if at all, if they have reasons for not filing the written statement, they should have made an appropriate application before the expiry of 90 days, Lordship. Now, it is not like some other proceedings for which you can just seek adjournment without any written application or without filing appropriate application.
Supported with an application. Your prayer should be supported with an application. Apart from that,
In
you
that
have said
case-
that he is not well and also that medical.
In that case, Your Honor, I may be allowed some time, a day or two, maybe. I'll do all the appropriate steps and then I'll be back, Your Honor. Because I have to, because the conducting counsel is also out of the station, so.
Who is the conducting counsel?
K double.
Notice.
I was instructed that I maybe take the adjournment for today and then it may be fixed for.
But he rightly
after.
said it is a case where the procedure of the civil procedure code will be applied for the entire proceeding. So in that case also, and as per the rule 1.8 also, the 90 days is a period of limitation. So beyond that limitation, you are going to pray without any application.
That I understood, Your Honor, but the conducting counsel is also outside the station. So I may be allowed some more time, Your Honor.
Lordship, by not filing, despite the receipt of service of notice, Lordship, by not filing the written statement within a period of 30 days, they have already, Lordship, they have already relinquished their right, Lordship. Now, as I have already said, 86(7), Lordship, Section 86, subsection 7, it says that it has to be, the endeavor shall be made by the Honorable Court to dispose the election petition within a period of 6 months. And that too coupled with Order 8, Rule 1, Lordship, where it says that 30 days, and beyond 30 days, it can be extended up to 90 days. But however, there has to be, reason has to be recorded. Now, they do not have any, they are not coming up with any appropriate application. And if at all they have any reason,
Although
they have to come up with appropriate application, Lordship. So may I pray that this matter may be proceeded ex parte, Lordship.
although I written
In regards to two, right, I mean, the respondent number 2
To,
is not.
with regards to,
Your file your affidavit.
yes,
regarding the
that,
justice service.
in the same affidavit, Lordship.
Notice is served to Dusty Moore.
Yes, the stay. With regards to respondent number 2, Lordship, the stay was served on 3rd, Lordship.
Third of
Respondent number 2,
August.
Lordship, 1st August. Respondent number 1, 2nd August.
If suppose matter is listed after day after tomorrow, in fact. In that case, will you be able to file your written objections?
yes, Your Honor.
No, you're saying yes, but your senior is not there. You have to prepare the petition.
Yes.
It is already prepared.
It's already been prepared. It's just that the swearing part is due.
Yes, 8 attack. Your 8 attack, no?
Lordship.
Pardon, Mr. 8 attack, number 30. The learned counsel for the petition and also heard MS. Your MS?
D. Riba.
D. Riva, the learned counsel appearing for the respondent number 1. From the office note, no, the respondent number 1. However, the respondent number 2 is, but none has represented the respondent number 1. So, from the affidavit filed by the petitioner, it is seen that the notice has already been served to respondent number 2 on 1/8/2024 through Dusty Moore. And in that to that effect, they have also filed their affidavit. Accordingly, it is submitted by Mr. Tata that the matter should be proceeded ex parte against the respondent number 2. Next, madam. MS Riva, the learned counsel for the respondent number 2, respondent number 1, is submitted that the written statement has already been prepared, but due to some health condition, the respondent number 1 could not appear before the court to put his signature and to file the same. She accordingly submitted that she may be allowed to 1 or 2 days to file their written objection, of the written statement for the respondent number 1. Mr. Tata submitted accordingly that the case has to be proceeded as per the procedure under the CPC, which which says that and as per Order 1 Rule 8, it is the as per Order 8 Rule 1, the written objection has to be filed within 30 days from the receipt of the notice. But even after the lapse of 90 days, the respondent has not filed his written statement of the objection. And accordingly, he submitted that the matter may be proceeded ex parte against the respondent number 1 also. Now, MS Riva submitted in this record that they may be the matter may be fixed tomorrow. It can be, or day after tomorrow.
Day after tomorrow, Your Worship.
Matter may be fixed on the day after tomorrow. And they will be able to file his data written statement. Thank you. Next paragraph. After hearing this submission made by the learning counsel for the both sides, it is seen that it is that the service notice was served on 2/8/2024 against the respondent number 1, but even after expiry of 90 days, they could not, the respondent number 1 has not yet filed his written statement. However, considering this submission made by the learned counsel for the respondent number 1, let the matter be listed tomorrow. Day after tomorrow is a 6. On 6/11/2020, enabling the respondent number 1 to file the written statement of the objection. Let the matter be accordingly listed on 6/11. So I'm giving you day after tomorrow, just file it. Because he rightly submitted that it is as per CPC has to be followed, and as per the act, that's going to be disposed of within 6 months. But we have, I had some personal problem also. That's why I asked the registry to fix the matters where my bench is here. Because what had happened, actually, I was in division bench. Up to 4:30, 4:45, division bench was continuing. So thereafter, due to paucity of time, it could not be taken. Okay. So I asked the registry to matter may be listed so and so. So accordingly, it is listed. So I want to at least order may be there.
Lordship.
So I'm just fixing it on 6th. Let us see.
Lordship. Deeply obliged.
Much obliged.
31 is already come. His affidavit, petition, in application already. 4 questions, I think. 4 questions. That question. For interlocutory, I research. Yes, we have.
In here, Malab, I filed an application praying for deferring the filing of the written statement, Malab. On the ground that we are filing, Malab, we could have filed today, but due to that, as we could not obtain the relevant certified copy, Malab, we could not file, Malab. So we'll be filing this our application raising maintainability of the election petition within this week itself, Malab. So once the election, if the maintainability it is allowed, the entire trial need not to be go on, Malab. That is why, Malab, the preliminary objection we are raising, Malab, the ones we'll be filing this week only.
Lordship. May I please, Lordship? Lordship, even in the instant case, this matter was taken up on 30/7/2024. Thereafter, notice was issued to the concerned respondent number 1 and respondent number 2. And accordingly, the petitioner has taken justice service on the respondent number 1 and respondent number 2 on 6th of August. Now, 6th of August will be a day after tomorrow. The 90 days period will be completed.
August, you have taken steps, or it was served on 6th of August?
6th of August. Dusty mode, Lordship. And then even the true register post, it was taken on, steps was taken on 31st. Now they have already received the copy of the petition in the on 6th August 2024 now. So if we compute the time from the service of notice 90 days period will be expiring by day after tomorrow, Lordship. Now, may I pray that at this stage, let them file their written statement within this stipulated time. As I have already submitted, Lordship, it has to be written statement has to be filed within a period of 30 days. Now, at the most, it can be extended up to 90 days. That I have already submitted. Now, with regards to this application, Lordship, the application for this application, although they have filed it in the form of interlocutory application, Lordship, but it has to be proper, as I have said, as I have already, Lordship, submitted, that this application has to be, if at all they are seeking adjournment, they have to file the application under the appropriate provision of Civil Procedure Code, Lordship. So may I pray that this matter may be fixed a day after tomorrow, so as to, since Lordship has already considered the other case, let them file the written statement
May your lordship.
by 90 days.
In regards to R2, I have filed my wakalat number as well as written statement today, your lordship. I have already, yes, your lordship. Returning officer. Respondent number 2.
Respondent number 2, I have already received
I've already
a
served
copy
the
of the
copies.
written statement of respondent number 2.
We have already filed.
Yes, your
Yes.
lordship.
Respondent number 1, we are appearing for the first time today and we have filed Wakalatnama today. So since we have already filed the adjournment seeking ground that we are raising maintainability. Once the maintainability is, if it's decided, that nothing remains. That's why, it may not take much time. We this week we'll file and next week we can decide the maintainability. It won't take much time. It's for betterment for all.
Lordship, the provision is very clear with regards to order 8, rule 1, Lordship.
Will it be betterment for him also?
But that is clear. That's why,
No. Yes, I have to read answer. Supplementary answer. I have to answer supplementary code. I have to. Yes, there will be 2 orders, one in I and other one in data. So in I write, no. In I you can write. I number 206/2024. Now it is an application praying for deferring time for filing the written statement by the respondent number 1, wherein the respondent number 1 has raised some issue on maintainability under section 86 of the Representation People's Act 1951, challenging the maintainability of the election petition filed by the petition. It is submitted by Mr. T. Tarum, the counsel for the respondents, appearing for the respondent number 1, that the written objection has already been prepared and they have appeared today, filing Wakalatnama on behalf of the respondent number 1. But due to non-availability, some of the documents which were required to be filed along with the written objection / statement, it could not be filed today, and hence by the interlocutory application, the respondent number 1 paid some more time to file the written objection. Next paragraph. Mr. V. Tata, for the petitioner / respondent, submitted in this regard that this notice was served on the respondent number 1 on 6/8/2024, but till date they have not filed their written objection statement, and accordingly he submitted that on 6/11/2024 this period of 3 months will be over, which is as per and within which the respondent had to file the written statement as per the procedure of the CBC. Next paragraph. However, considering the submission made by learning counsel for both sides, the present application, interlocutory application is allowed for praying for adjournment to file the written objection of the statement, written objection of the statement by the respondent number 1/ the present petition. With a direction to file their written objection on or before the next date of listing. With the above observation, the present IA has been disposed of. Network flexible. Sorry. Under R1E2 applicable, heard Mr. A. Tata, the learned counsel for the petition, and also heard MSA under the counsel for the respondent number 2.
Lordship,
The comment advocate, I think. Comment advocate.
returning officer, standing counsel.
Written officer of returning officer of so and so. And it is submitted that they have already filed a written statement on behalf of the respondent number 2. In post in view of the order passed in IA, in view of the order passed in IAC 206 of 2024, the respondent number 1 is hereby asked to file his written statement of the objection on or before the next date of listing. List accordingly when it can be listed.
Can you list on 14?
Lordship, there has to be certain reason, as I have already submitted, for extension of time, Lordship. There has to be some plausible reason. Now,
He submitted as per him, he supposed to file it, but there are some documents which are required.
Lordship,
Because he is raising the issue of maintainability.
Lordship,
That is-
that's, of course, that is their Lordship, but however, Lordship, he has, the respondent number 1 has got enough time, Lordship. This, since he have received the service of
Yes,
the
obviously.
notice.
That cannot be denied. Yes. definitely.
Yes, and then,
Yes, when it can be filed.
Regarding maintainability, we'll file this week only. On the 7th, by 7th, we'll file on maintainability.
as well as the written statement, Lordship. If they can file, preliminary objection or any appropriate application within a week time, they can file the written statement within a week time, Lordship.
I mean, what is to say, you can raise the maintainability issue in the written statement or written objection itself. That can be taken up. Well,
My lord, one thing, my lord, the maintainability, my lord, it may have a separate issue, my lord, preliminary issue may be required.
that's what I'm saying. If you file your written statement with that particular, I mean, that the issue is not maintainable and mention why it is not maintainable. That issue as per the CPC guideline, that issue may be taken up for consideration as a maintainability issue or a preliminary issue. That can be
Yes,
taken up. It can be heard.
Lordship.
There is no bar.
My lord, in that case, my lord, since we are preferably we are ready for, my lord, this maintainability, my lord. In that case, my lord, can it be on 14, my lord?
And if you want to file the written objection also,
My lord,
along with the maintainability.
my lord, if that is my lord. My lord, if my lord agree, my lord, it's allowed, my lord. I may be allowed to first file the maintainability, my lord, in this week, my lord. We'll decide even by next week only, conveniently, if the party is ready, my lord, we can.
Lordship, that is what I'm submitting. If the respondent number 1 can file written statement with, file an appropriate application raising question on the maintainability, Lordship, then they can file their
Otherwise
written
also, if it is
statement.
basic intention of for your petition is the
It is-
maintainability,
In fact,
then
Lordship,
obviously that can be incorporated in your written statement also. That issue can be taken up.
Let it be on the 14th, my lord. 14th, that will go, my lord.
Okay.
Lordship, for filing of written statement as well as any
As well as-
appropriate application.
It is so and so for filing of the written statement, says the application issue of maintainability.
Deeply obliged.
Here also one I was.
Yes, may I?
I is for,
Your Lordship, IA has been filed by District Election Officer, Your Lordship, for releasing of EVM, Your Lordship.
Madam, two IA, madam. One IA is by the private respondent and another IA is, madam, the
IA
district,
126.
no, one I
election
is by
officer.
returning officer for releasing
Madam.
EVM machine.
Yes.
And other one?
Other one is for filing, madam, the written
Today
statement.
20. IN number
205 is filed by you.
Yes, yes,
This is for what?
for filing of written statement and
As a-
written objection.
Otherwise, it is an adjournment. petition.
Yes, Your Honor. Along with written statement, simultaneously, I will be raising the issue of maintainability with the written statement itself, Your Honor.
Madam, my submission is, madam, in madam, main election petition, madam. Madam is aware, madam, the election procedure is such a procedure where it has to be go strictly, madam. These are the, madam, the IAs and the other things are the, madam, the offshoot of the, madam, the main proceedings, madam. Now, madam, today I'll not, since they have come with the IA for filing the necessary, madam, the written statement with these applications, madam. Madam, I'll not, madam, be insisting for the, madam, the expertise, madam. Madam, what law says, madam, is very clear. As per the, madam, CPC, the filing of the written statement within a period of stipulated period of 30 days, before the
Can be
expiry.
extended.
Yes, madam. Before the expiry of 30 days is one thing, madam. Before the expiry of 30 days, if they are not in a position to file the, madam, the written statement within a period of 30 days after the receipt of the, madam, the notice issued by dishonorable court. However, madam, before expiry, madam. Then, madam, if not in a position to file the affidavit, madam, the another, madam, the outer limits is 90 days, madam. So therefore, the first opportunity they have already lost, madam. It's because the copy has already been, madam, they served long days before. And the
When we
time
get-
period is, madam,
when we
expired.
get-
Madam,
Kubar affiliate.
private respondent, madam, to that effect, madam, I filed additional affidavit. Page
এটা matter যে join করেছে।
notice was issued.
When they filed, when notice was served?
Notice was served on, madam, the 2nd August 2024, madam.
আচ্ছা।
By additional affidavit, madam, I
Yeah, fine.
stated. It was served on, duly served on 2nd August 2024, sir, which was expired on 1st September 2024, madam. 30 days expired. From 30, madam, 1st September to till date, madam, they have not filed any, madam. Madam, what I'm submitting is, before the expiry of 30 days, they ought to have filed applications praying for the, madam, the extension of the time for filing necessary written statement, madam. Therefore, they have not done. So that, madam, the opportunity is, madam, they have lost. Another, madam, since today they are praying for the, madam, the extension of time for filing written statement by this IA, madam, IA, Lordship may kindly take up the IA 205, madam, filed by the sole respondent. This is also not as per the format, however, madam, I'll not go to so many mistakes are there. However, madam, I'll not go to that extent, madam. Since at least affidavit, madam, IA has come for praying for extension of time. Madam, what I'm submitting is the documents which they wanted to, madam, the adduce before this honorable court is not specific, madam. Just may I take your lordships to para 1. The specific abutment made by them is not, madam, the ambiguous. This is very, I'm sorry, madam, this is very ambiguous prayer. It has to be, madam, the specific, madam. Merit, madam. I'll skip just to shorten the time of this honorable code. Page number 4. I promise it starts from. Then he has yet to file his written statement in regards to the case, and he needs some more time in filing the written statement as he is yet to get and obtain some documents for filing the written statement from across the state. What are those documents which he wanted to? So therefore, madam, I'll not, my lord, pray for the, my lord, the ex parte proceedings. Rather, my lord, my prayer would be, my lord, specific short date may be given. My lord, so that he can file, my lord, is the written statement. And after, my lord, that within that is, my lord, the stipulated period, if it is not filed, my lord, the ex parte proceedings may be, my lord, passed. Order for the ex parte. That is my,
Your Honor, in regards to the documents, by yesterday evening, we have all the documents has been furnished to me, and we'll be filing by this Friday, Your Honor.
my lord.
By Friday.
Yes, along with our preliminary objection.
Maintainability.
Yes, Your Honor.
my lord.
Same order more or less. আগৰ যিটো order আছিল regarding the adjournment prayer, it was you dispose of this application also on the same line. However, he will submitted, he further submitted that the written objection will be filed on Friday is what?
8, my lord.
8 of so and so, along with the issue of maintainability.
My lord.
তেতিয়াহ'লে this adjournment application or the interlocutory application can be disposed of. Yes.
List again on, my
Now-
lord, 8, my lord.
8, yes.
For written statement, filing of
Yes,
written.
for statement.
Obliged.
Similar order of আগৰ নিচিনা না? Now coming to the another I.
Another I, my lord, that is releasing of the EVM machine, my lord, that we don't have any objection.
You don't have any.
Yes, my
objection
lord.
there.
Basically, our contention is on different aspect, my lord.
Not in regards to EVM.
My lord.
Now into IS. But you are representing returning officer also, no?
Yes, no, here we have not been made party, Your Lordship. We are not party in this election petition, Your Lordship. Your Lordship, may I place one coordinate bench has passed a similar order wherein my IA was allowed, wherein
It's okay, but you have not.
Basically, implement
No,
has to
they
be.
have not implemented.
no, no. Your
Implement has to be done first, my lord. Then, my lord, since we are not agree with the, my lord, the district election officer or the election commission.
So then how it will be disposed of?
Exactly. That
Your
is the
Lordship,
one.
in
How it can be disposed of?
Yeah, please, Your Lordship. Lordship, there is a instruction from Election Commission of India that wherever there is election petition, all the EVMs should be kept in custody so that Honorable Court may direct such order wherein the records may be called for. Therefore, as a abundant question, we kept all those EVMs wherever there is election petition. Therefore, now we come to Honorable Court seeking permission that if EVM is not the question in that very constituency, then Honorable Court may be pleased to allow us to use that, take out that EVM and use it for some other elections. So as your Lordship, EVMs, because of shortage of EVMs, sometimes it is transported to Bihar, sometimes it's transported to Bengal, etc. So therefore, it is
It's
required.
okay. They also do not have any objection in returning the EVM machine.
Yes.
But the question is that you are not being made party, rightly or wrongly, whatever, you are not being party in this case. Returning officer is not being party here.
Yes.
But now that is the issue. That's why I'm asking is whether she is returning officer. So in that case, how to pass the order, because you are not in the
Lordship, we have been doing this since last election also, last assembly election. This year also, Lordship, we have already obtained two from this coordinate bands, such order.
there you are party or no?
No, we are not party. We are not
But
party.
it's a proper way is to that they should be party in this case, and so that they order, they can a regular, I mean, at a order to maintain the order. In fact, you should be a
Procedure
party.
wise, Lordship is right, procedure wise.
Procedure wise.
But sometimes it will multiply the litigation.
May I, Your Honor? That's the issue that I'm going to raise in the maintainability, Your Honor. There are lots of contention in their petition, which says that the district election officer has done certain things which have favored the return candidate. That's the issue that I'm going to raise in the maintainability.
Okay, you will raise those issues. Yeah, I do.
However, my lord, we are not any, we don't have any objections for
In
releasing of the
returning.
EVM
Yes,
machine.
yes,
But
okay.
it will first go. Coordinate the answer for fast.
So you made respondent here.
Yes, ma'am. Opposite party. These parties are not raising any objection, madam. This may be, IA may be allowed, madam.
Now, who is the petitioner here? The election officer. I mean, returning officer. Who is the petitioner here? The petitioner is there.
District
The
returning officer.
designation is not there.
District
There's-
election officer.
See here, the petition you see. Where is the building? Fully fine. Key हो. Is it he is a private person or any?
Malad, he's the, Malad, the candidate.
No, it's candidate. Other one who is asking for or paying for returning this one is there.
Malad, district,
Designation
second page, Malad, this district election officer, Malad.
is there?
Yes, ma'am. District DO, Malad, in short form, it has been written, district election officer, West Siang district, represented by Sri so and so, Malad.
District election officer.
Malad. He is the applicant, Malad, and thereafter, Malad, the petitioner's name and the return candidate. Opposite party.
Part Sir A. Apang, yes, senior advocate assisted by Ms. A. Anju. He even do number I to so and also her Mr. M. Patu, the Permanent Council appearing for the respondents less the petitioner in election petition number 06 of 2024. Next, where this application has been filed, praying for release of the electronic voting machine, EVM, for further use, which is kept in strong room under the custody of the district election officer Alo West Siang, in respect of 27 Liromoba ST Assembly Constituency. It is submitted by Mr. Anu that the election petition number 06 of 2024 filed by the present respondent is still pending for disposal. And since there is an election electoral liquidity pending for disposal. But it is submitted that the EVM machine is still under the custody of the district election officer in the strong room in anticipation that said EVM would be the subject matter of the election petition. However, from the election petition, it is seen that this is not the subject matter of the election petition, which is pending before the court for disposal. And accordingly, it is prayed by the district election officer to release the EVM machine, which is kept in the custody of district election officer in the strong room. Mr. M. Kato, the learned counsel for the petitioners as respondent, raised no objection and submitted that this is not the subject matter of the present petition, and hence he has no objection in releasing the EVM machine in favor of the present petition. Next, considering this submission made by the so and so, the present interlocutory application is allowed, directing for release of the EVM machine it is of 27, no? When constituted.
27, Liromapa Assembly Constitution.
Release of so and so, which is in relation to 27 to Disilu constituency. And the present petition is at liberty to if you have observation, I think okay, it is disposed of.
Well,
And now come to election petition. So we are fixing it on
8 months.
8.
Friday month.
So we are fixing it on 8.
Yes.
Here also only one respondent is.
Madam, sole
Yes.
Heard Mr. M. Kato, the learned counsel for the petition, and also heard you are Mr.
R. Raksap. R. Raksap.
R. Raksam for the respondent number 1. In view of the order passed in IA 205 AP 2024, the respondent number 1 is hereby asked to file his written objections statement with the issue, raising the issue of maintainability on or before the next date of listing. List accordingly 8/11/2020.
Along with the written statement.
Along with the written statement, you raise the maintainability issues.
Oblige.
Bukaya disposals, eh? What do you want to say? Okay, 29. It's no problem. Mm. 39, 38 is the same I.
38, Your Lordship, IA 169 has been filed by me, Your Lordship.
For same
For,
returning.
no, for striking of Election Commission of India and Chief Electoral Officer. This has come up for the first time, Your Lordship. Election petitioner is not present today, Your Lordship.
Petitioner is not, today is not, petitioner is said is not present. Aku orang matak sun 89 ada petitioner. Petitioner said to 9.
Notice may be issued.
Otherwise, you are representing respondent number.
Otherwise, I'm representing respondent number 1 and 3, Your Lordship.
1 and 3.
Lordship.
One and 3. So it isn't pay to strike out the name of respondent number 2. You are paying to strike out the names of respondent number
1 and 2, Your Lordship.
1 and 2.
Your Lordship. 1 is Election Commission of India and 2 is Chief Electoral Officer. And for 3 in the main election petition, I have already filed a written statement for returning officer.
For 3.
For 3, Your Lordship, in main election petition.
And you are for representing
I am for the return candidate, Lordship. Respondent number 4.
4.
4.
Petitioner side 9.
Respondent number 4, Lordship. I am yet to file my written statement, Lordship. Still time is there, Lordship. It has not exceeded 90 days.
The statement, but for 3, it has already been filed.
3 I have already.
3
Already
written,
filed,
written.
yes.
Returning officer, I have already filed.
Already filed, okay, yes. No one has represented mean to order for, I'm coming to this one. Mean to order for election petition. Election petition, we will say number 39. No, sorry, 13. 39 is the election petition, 3. Is the election petition 3, no? Election petition 3. Now has represented the respond number, okay, sorry, petition. Her MS ANJ, the learned government advocate, who is representing the respond number 1, 2, and 3. And it is submitted by her that she has already filed the written statement on behalf of the respond number 3. Further, it is submitted by Mr. M. Taloni. Taloni, your name, Mr.
I am J. Gini, Lordship.
J.
Gini.
Oh, Gini, sorry. In this paper, Mr. J. Gini submitted that he has also already filed. Oh, no, you have to.
I am yet to file.
Yet to file a written statement on behalf of the respondent number 4. And on or before the next date of listing, he will be filing the written statement. List in matter accordingly. You can file within this week or
Within 10 days, Lordship.
within 10 days. Then the same problem will be there. 10 days to ketia lage hobo. 14 will be 10 days. 14. ঠিক আছে, did you? 14. Itu tanai koribo. And now you come to this IA. Your IA is 169.
There are 2 IS, Your Lordship.
No, no.
169.
One striking out is 1.
One is striking off, one is releasing of EVM, same prayer.
Yes, okay. Then one. In both the issues, we are going to issue notice.
Yes, Your Lordship.
In both the matters, IA 169 and IA
144.
144 issue notice. We are not represented, otherwise can be have it. But here you have your party as a
Yes, Your Lordship. Yes.
There you are not party, but here along with you, the other 2 are also party.
Yes, Your Lordship.
Okay. Okay, well, issuing notice.
Obliged.
Same date will do or
Same date.
same
Your
date,
Lordship.
14.
Yes,
Okay, 14 days.
obliged.
Yes, Anil.
Yes.
In short, my lord, my case, my lord, state of Arunachal Pradesh, my lord, issue, my lord, NIT, my lord. The name of the work, my lord, is Eco Tourism Village at Japa, Tabiang Village, Nyapin, Kurungkume District, phase 1 under budget estimate B2000 for a estimate. This is the name of the work, my lord. Now, what happened in this case, my lord? On recall, my lord, NIT was issue, my lord. NIT was issue for this work, my lord, for 5 crore. I participated, my lord. Agreement was drawn, my lord. Now, after agreement drawn, my lord, finally I even started the work, my lord. After execution of my lord, 50% of the work, my lord. The Department of Tourism, my lord. This NITS, my lord, issued by other respondent, it is my lord, PWD, my lord. The work, if my lord, PWD, my lord. NITS issue, this whole work was for me for the tourism department, my lord. But then, as my lord, this work, my lord, was NITS issued by the PWD department kurung kumai, my lord. Now I started the work 50% completed, my lord. In the meantime, my lord, a letter, my lord, was issued from the tourism department, my lord, directing the executing the department, my lord, that is PWD, my lord, to prepare the DPR, my lord, and let the work, my lord, be limited up to 50 lakhs only, my lord. Earlier, my lord, NIT was issued for 5 crore, my lord. Agreement, agreement interpreted, my lord. I executed the work.
You have completed 50% work. also.
50 after 50%, they saying that now, my lord, that I challenge, my lord. Now I is put in challenge in this petition, my lord. This letter, my lord, directing the
Now, what, after 50%, what was the order there? They?
order or they.
You've been prevented from doing the remaining 50% of work.
No, my lord, no, my lord, no, my lord.
What was the order?
Oh, they a letter, my lord, letter by the tourism department, my lord, directing the PW department, my lord, to re-prepare the work, my lord. I put that on challenge, my lord. Put that was step by this and report, my lord. Now, in terms of earlier agreement, my lord, I entitled to complete the work, my lord. But as my lord, this execution of work, my lord, requires some fund also, my lord, in the fund in the midterm, my lord. But they did not release that also, my lord. Now, issue, my lord, that I put on the now, I hope for whole the issue, my lord, I obtained a record of the official record, my lord, the RTA, my lord. Now, what was the basis of that, my lord, letter, my lord? That letter, my lord, by the department, my lord, was issued only on the basis of, my lord, official note of the concerned minister of the tourism department, you own not, my lord, saying that no, my lord, that work was only for 50 lakhs, my lord. Now, to ascertain that, my lord, I further obtained the RTA, my lord. Now, RTA revealed, my lord, this is part of record, my lord. RTA revealed that, my lord, this work, my lord, was approved by the sub-cabinet, my lord. Sub-cabinet means, my lord, CM, the Minister of the Tourism Department is said, my lord, including finance minister, my lord. That is a matter of record, my lord. Now, basic, my lord, my legal issue, my lord, I have whether, my lord, the decision that the appropriate government, my lord, that is the subcommittee, my lord, can be overturned by the single minister, my lord. That, my lord, I believe, my lord, that is already settled by the apex, my lord. That is absolutely not, my lord. Now, last occasion, my lord, on this basis, my lord, as they have filed affidavit by saying that this whole record, my all contention is right, my lord. Therefore, my lord, this honorable, my lord, directed the learned additional AG, my lord, to take instruction whether, my lord, they want to continue the work, my lord, in terms of their affidavit, my lord, or what is their clear statement.
Which order? The additional AD was?
Order dated, my lord, 25/7, my lord, I believe, my lord.
25/7.
Oh, it is. No, my lord, it is an.
It was further time, I think.
At 19, my lord, 19/7, my lord.
19/7.
For further instruction, my lord. Now, if, my lord, there is, they want to continue, my lord, I believe, my lord, it's okay, my lord. This case can go, case can be closed, my lord. If they are saying no, my lord, they want to go, then I have to argue the matter, my lord.
Yes, anything in continuing have you taken any instructions?
Yes, my lord. In fact, two contradictory stands have been taken in this case. By the PWD, it is favoring the petitioner. By the tourism department, it is, they are restricting the expenditure till 50 lakhs, my lord. Whereas the NIT was floated for 5 crores.
For 5 crores.
5 crores. Agreement is entered for that. Now, I have spoken to the Secretary to Tourism also. Yes, since there is also a technically mistake because the minister concerned could not have single-handedly cancelled the cabinet subcommittee's recommendation. On that ground, we will go by the affidavit filed by the PWD. So we will not take the stand of the tourism department. That is my instruction.
So you are on affidavit filed by the PWD now?
By the PWD. that since tender was for 5 crores, that project should go on. Project should
What
be.
about the tourism department by the interfere?
Tourism department, the interference was because of the minister's note restricting the total sanction from 5 crores to 50 lakhs. Whereas
What difference? 5 crores to 50 lakhs?
50 lakhs, because that was on the direction or not of the minister concerned, minister himself. But this they had followed this, so the project was to be limited to 50 lakhs as per the tourism department. But I've spoken to the secretary tourism also now that this could not have been done in view of that approval by the cabinet subcommittee, which is the approving committee.
Yes.
Malad,
Now, where is your affidavit?
In our affidavit in of the PWD, my lord.
Five, six, 5, 6, 7, and 8.
5, 6, 7, 5, 6, 7.
5, 6, 7, and 8, my lord.
5, 6, 7, and 8.
Reclaim bitong missing.
So 9 is the Minister of Tourism. Number 9.
My lord. My lord.
And who is representing the tourism department?
Tourism, my lord.
You are representing tourism department. Well, you go by the affidavit filed by 5, 6, 7, and 8, but you have filed your separately affidavit?
5, 6, 7, and 8.
No, 5, 6, 7, and 8. You are going by this 5, 6, 7, and 8. For one, have you filed any?
2, 3, and 4 for the tourism department.
No, 2, 3, and 4. You are not supporting 2, 3, and 4.
No, my lord.
So these are their tourism, Department of Tourism.
Yes.
And 1, what about 1?
1, my lord, therefore, my lord, 1 is the chief secretary, my lord.
Is supported by 5, 6, 7, and 8.
Yes, ma'am.
2, 3, and 4 has also filed their written.
Yes, my lord.
You have filed your objection. So now they are with PWD department, that is, it was for 5 crores. How can it be on the single-handedly by from the minister? It can be on 50 lakhs.
Yes.
So what is your say there?
I am for the tourism department, respondent number 2, 3, and 4.
2, 3, and 4, yes.
So earlier, my lord, the counter affidavit filed by the PWD and tourism department was contradictory. So, but now I have the instruction not to press the counter affidavit filed at the tourism department. And I
2, 3, and 4.
Yes, 2, 3, and 4. And I have been instructed to submit in consonance with the PWD, affidavit filed by the PWD. So on instruction, I'm not going to press the affidavit filed by the tourism department.
Otherwise also, my lord, in the epidemic by tourism department, my lord, also support my case, my lord. They are not saying, my lord, the agreement was not for the 50 years. They have filed a agreement also, my lord. That is saying that this is 5 crore, my lord. Only by simply, my lord, they tried to usually avoid it by putting the UN of the concerned minister, my lord. The agreement, my lord, into they have also not disputed, my lord. They are also accepting just that was hold the sub cabinet committee, my lord, approved the 55 crore, my lord. Only on the instead of the concerned minister, my lord, they have issued that letter.
9 is also represented by someone or it is?
Nine,
Because
nobody.
on his note, most probably the order was there.
Well,
Where is the order of this page?
9, my lord, no, nobody, my lord. But then, my lord, 9, at this stage, my lord, he is no more, he is not the concerned minister, my lord. So he is
He was made party by name only.
my lord, my lord, but he is not the
Anyway,
minister.
now where is the order or where is the circular? Where is whereby it has laid down to 50 lakhs. Sanction order is in 38. Have you annexed that order? Even note and all?
Pardon, my lord.
Note of the ministry and all you have annexed here?
Minister, my lord, you or not, my lord. In
Even notice?
epitome of respondent number, my lord, 1, 2, 3, and 4, my lord, that is at page number 104, my lord. This is the you or not.
104.
104, my lord.
Equity could by 2, 3, and 4 like 8 to 5, 6, 7, and 8 or 7. 2, 3, and 4.
In my read petition, my lord, also that is dear, my page number 53, my lord. Page number 53, my lord. 53, my lord.
5, 3.
My lord. This is the you or not, my lord.
2, 3, and 4. Here in 553.
53, annexation number 7, my lord. Now, page number 68, my lord, will kindly have a look. Page number 68, my lord. 68, my lord. 68. How, my lord, this, my lord, approval of this, my lord, or initiated, my lord. Page number 68, my lord. This is the how this started, my lord. Now, my lord, will see signature of the deputy director, down below director, my lord. Next page 69, my lord. This I obtained through RTA, my lord. Secretary Tourism, my lord. 69, my lord. Down below, minister himself, my lord. Earlier point of time. Thereafter, my lord, finance minister, my lord. Thereafter, CA, my lord. Now, 50, these are approved by the subcommittee, my lord. The recourse say, my lord, this I approved. Now, after, my lord, how, my lord, he initiated his own, my lord. He himself was signatory to the, my lord, that approval, my lord. Page number 69, my lord. Therefore, my lord will record the submission of the additional advocate general, my lord, saying that, my lord, they want to continue with the work, my lord. And case may be closed, my lord, may humbly. The right in them to continue with the, my lord, agreement
Yes,
inter between.
Mr. Rotan, then the petitioner can be order can be passed to continue the order with the by the petition.
In terms of the contract, my lord,
In terms of-
agreement inter between us, my lord.
In terms of the tender, my lord.
In terms of the tender.
Okay, I'm disposing the order, pass the order.
Well, obviously.
Very long order. इसके बाद आगे pass the order.
14, my lord, we have raised the issue of maintainability, my lord. On the issue of maintainability, this writ petition will be decided.
My lord, rest of the respondent not yet filed reply.
That is not a factor, ma'am. We are only raising the issue of maintainability. What is the intention of the writ petitioner that has to be seen, my lord? My lord, if may I, my lord.
My lord, sanctioning authority, the head office is Shillong. They is cancel the proposed scheme. Cancel the proposed scheme.
Why, my lord? Why, my lord? Because of them, my lord. That is why I want to
Yes.
show the my lord, intention of the writ petitioner.
Who are the other respondents?
The
But I-
deputy commissioner, my writ petition arising out of the non-acceptance, acceptance of the complaint lodged before the block development officer Mengyo. So video has to appear to file the affidavit.
Oh, we have filed,
without
We have filed, my lord.
no video and deputy commissioner also.
Deputy commissioner not necessary, my lord.
The video why not entertain my application? Then we representation submit before the deputy commissioner, and thereafter we lodge before the advisory office Shillong. So accordingly, their proposed scheme has been.
Who are the respondents who has not filed yet affidavit?
Five, my lord, deputy commissioner, they are not a necessary party, my lord.
3
They are not
and
going to
5.
file.
3 and 5 is not yet not filed.
My lord, 5, my lord, service of notice upon respondent 5 is complete, my lord. My lord, on
3 and 5 you are representing?
13th.
I'm for respondent number 3, Your Lordship. We are not a necessary party.
Well, you are not going to file any affidavit in opposition.
No, Your Lordship.
You are not going to file an affidavit.
Yes, Your Lordship.
My lord, the
And-
direct connection with the official communication between IC Deputy Advisor NEC Shillong to UPRDC. Now UPRDC is the necessary party in this case. So UPRDC has to file reply.
You have already made party, it's okay.
Yes,
So
yes.
that we're not going to strike out their names, but they're not going to file their affidavit in opposition, it's okay.
Yes, ma'am.
So Picha is for
Respondent number 1, 2, 4, my lord.
1, 2, 4.
Yes, ma'am. Look, I say, my lord, what I am submitting.
Five.
Let them,
Remaining only 5.
1, 2, 4, you have already filed your affidavit.
yes, my lord. 5, my
What
lord.
about 5 you are saying?
Five, my lord.
Only remaining respondent.
No,
5
no,
need
my
to
lord.
file.
Notice upon respondent number 5 has been already completed on 13/2/2024, my lord. File noting, my lord, 13/2/24, my lord. It was already submitted before on last occasions also, my lord. On many occasions I have submitted, my lord. Now, they are delaying the case, my lord. What is their intention? That has to be seen, my lord. That is why I am saying, my lord, let me show them their intention, my lord.
So in pendency of this case, my lord, in pendency of this case, the respondent number 5 has cancelled the proposed scheme. So that's why the respondent number 5, their affidavit in reply is necessary.
Well, notice is complete. If they are not filing, my lord, it is deemed sub, my lord. My lord, file noting dated 13/2/24, my lord, may be seen, my lord.
So more or no such stage they are passed by the Sambal court.
So, my lord,
So,
that is why, my lord, let the
agency.
issue of maintainability be decided, my lord. May I, my lord? May I submit, my lord?
No, wait. Already 4. No?
Well, we are facing problem, my lord. Why, my lord? The contractors have completed the work, my lord. Now they are asking money from us, my lord. Now NEC, because of them, my lord, the NEC has also, my lord, stopped the scheme, my lord. Now they are not funding the scheme, my lord. Now we have, my lord, we are the, my lord, tender issuing authority, my lord. We have issued the tender, the contractor has done their work. Now because of them, my lord, the scheme has been halted, my lord. The NEC has halted the financing of the scheme, my lord. That is why I want to show what is their intention, my lord. Whether they have the locus, my lord. What happened due to their constant complaint, my lord? We have first cancelled the NIT. My lord. First NIT was done, we have cancelled it. We have again made the second NIT, my lord. Now, my lord, on 11/11/2023, my lord, we have issued the second NIT. Now they are not participating in the NIT, my lord, second NIT also, and on 14, my lord, just 3 days after, my lord, they file again complaint, my lord. They are not participating in the tender process, but they are complaining, my lord. Now, what is their right, my lord? Without participating in the tender process, my lord, what is their right? How their right has been affected, my lord? What is their locus, my lord? Whether the writ petition is maintainable, that has to be seen, my lord. I would like to place one judgment, my lord. Only one judgment. AIR
2022.
2022.
No.
Day after tomorrow then, my lord.
My lord, here the subject matter, the subject proposed of this scheme subject matter is completely fall within the jurisdiction of the Panchayat Raj. The district, block development officer.
What prevented you from participating in NIT?
Yes, my lord.
My lord, here participating of the NIT is different thing. And here initially we lodged a complaint before the video. The block development officer is the office secretary of the Panchayat Raj, local self-government. There are 41 schemes which proposed to be implemented within the jurisdiction of the Panchayat. There are 14 numbers of Panchayat. The entire 14 numbers of Gram chairperson approached before the block development officer Mengyo to apprise the scheme, what scheme about to be implemented within the village. The block development officer is the office secretary of the local self-government.
That scheme
So
will not
without
be
informing,
beneficial for you.
without informing the local self-government, the block development officer is proposed to implement the scheme. That scheme proposed scheme is completely subject matter of the Panchayat as per 11th schedule of the Constitution.
So that scheme will not be beneficial for you.
Yes, of course, beneficial for us. Yes, we want for beneficial for public utility. But their block development officer proposed a scheme in the jungle. They are nowhere human residents.
That is not their case.
Yes.
My lord, please come to read petition page 9, my
So
lord.
that's the
Page nine.
independence of this writ petition. The sanctioning authority has accepted our complaint and canceled the scheme. So therefore, asking for their respondent number 5 has to appear before
Entire
this
scheme
number
has
4.
been cancelled now.
Yes.
No, not
It-
exactly, my lord.
Cancel. I have filed the affidavit in reply. Affidavit in reply, page number, affidavit in reply. I enclose the cancellation order.
My lord,
Annexure A. I have enclosed the affidavit in reply. Their sanctioning authority has cancelled this proposed scheme on
Now, what is
15th
the
February
progress of
2024.
work at present?
well, work has been
Yes.
completed because of the reason, my lord. Now, work has been, my lord, NIT was called. They
No, no,
never
work has been
participated.
completed. Then now,
Yes,
now
ma'am.
he is saying that the scheme has already been.
Yes,
cancelled.
Because of them, my lord. Because of them, my lord. Let me show their intention, my lord. My lord, please can page 9, my lord, page 9 of the read
authority
petition.
has to file a reply. Independency of this case, some development has been raised, and the scheme proposed scheme is cancelled by
That would
authority.
not, my lord, that would not
Yes.
interfere, or that would not prejudice the read petition, my lord. Let them first show what is their locus, my lord. Whether the read petition is maintainable, that has to be seen, my lord. Other thing we will decide, my lord. We will pursue the matter before the NEC, my lord. Because we have issued the tender, my lord. Someone has completed the work. Only because of them, my lord, someone is suffering, my lord. And they are, my lord, hammering us, my lord. Because we have called the NIT, my lord. Now we are in the trouble, my lord. Because they will file a suit, my lord, later on.
The any bidder
My lord, page 9.
facing problem is only because of the video block
So you
development
are going
officer.
to argue the matter today or what?
No, I'm
No means your
I'm
first
praying for
meeting, huh?
yes, I'm praying for let the respondent number 5 be
5 is
filed.
I mean, the notice has already been served on respondent
Yes,
number 5.
yes.
He is not responding.
Yes, my lord. He is not contesting, my lord. Yes.
Now here you see, there is a note from the office note.
Yes.
Then,
Office note dated 8/12/2023 is also there. Issued.
So well then, my lord,
Process to register, oh no.
13-2, my
Let
lord.
the
13-2, my
Sorry,
lord.
13/2.
Yes, ma'am. 13-24, my lord.
fixing for another date
You
for
still want to await for service? Now, or you want what process you want?
yeah.
Not 13/2, 13/2, no?
Yes, ma'am. 13-24.
As per 13/2, service report in respect of respondent number 5 is returned back.
Yes.
True, from joint register, so and so, the High Court of Meghalaya, Shillong, after duly causing service of notice.
So
Then, in that case, you want to await for again for service or?
so well
No.
well in that case, let fixing for another date for hearing.
My lord, day after tomorrow, my lord.
Yes.
We have very
After tomorrow,
urgency.
lots-
that is
lots of matters.
There is urgency in the matter, my lord.
Okay, I can understand. Day after tomorrow, there are lots of matters have been.
My lord.
Thursday, Purva Parani.
Thursday, my lord. Yes.
Can be on Thursday? Thursday can be.
My lord, my lord.
Now for five, awaiting service for five is not, I think.
No, service upon notice is, upon respondent 5 is complete,
per
ma'am.
notice.
Yes.
Or do you have anything to other to say? Because five is not appearing.
Yes, ma'am.
It was served to the registry of the Meghalaya so and so. But apart from that, he is not appearing. So awaiting for his service will not serve the purpose.
Yes, ma'am. Yes, ma'am.
So he is raising some maintainability issues.
Yes, ma'am.
That under what locus standi you have filed a petition.
Yes, ma'am.
These are the matters maybe there. So we'll hear to it on Thursday then.
Yes.
Thursday for it. Thursday will be date will be
7, ma'am.
7. Based on Thursday.
Obliged.
Obliged. Matter বহুত আছে কি matter one of the equation
23 আছে না 23 24 But 23 is also there, I think. Hmm.
Twenty-five.
23, 24, 25. Financial. 23, 24, and 25 are similar matters. These are all NIT tender matters. Now, herein the basic cases, the petitioners in all these three cases, their bids were rejected at technical evaluation stage on certain grounds. Now, those grounds were provided to us by way of that bid evaluation committee's report. That report will also find that in case number 23, I don't know 23, I'm just placing this for one aspect. Otherwise, they have filed their affidavit and I'm supposed to file my reply. But while looking into their affidavit, there was a issue of grave concern that they have taken a duplicate. I mean, there has been a change of their stand as to what is in their report regarding the grounds for my technical bid being rejected. And in the affidavit that what they have taken, there is a duplicity of stand. So I would just therefore like to place what is in their report and then show your lordship as to what ground they have taken in their affidavit and thereby put the question upon them to prove it by way of evidence as to how there could have been a change of stand. Because the report says something and your affidavit says something. So it seems that all is not fair and transparent while deciding upon our case. So therefore, though I will file my reply, let them also on the next date bring before this court as to how could they have taken two different stands. So only for that aspect, I will just place that aspect. Because in the three cases, this has happened. But I'll just place item number 23, that will suffice. Now, in this case, if your lordship will come to item 23, WPC number 394. Now, this is basically otherwise a tender for construction of road. Now, the petitioner was a bidder. He had participated and his bid was rejected at the technical evaluation stage. And the report, lordship will find at page 120. Annexure 6, page 120. This is the bid evaluation report. What you've seen that. Now, if your lordship will come to page 121, 6, item number 6, evaluation of bids, serial number 2. That is HB Enterprise. Which was seen that? HB Enterprise. Now, his bid has been found to be non-responsive and the grounds have been stated. The first ground, if your lordship will see, as per evaluation and scrutiny of the following clauses have been attracted. So the clause 1 is clause 4.2.d of section 2 of the ITB. And this philosophy will just mark that clause. It says 4.2.d. Now 4.2.d, Lordship will find at page 35. So their first ground is that I do not meet the requirement of clause 4.2.d. So 4.2.d, page 35, if your Lordship will see, Lordship got that, page 35. Clause 4, qualification of bidder, 4.2, and then if your Lordship will turn the page, then D comes. Page 36, D. I'm just reading D, what it says. Evidence of ownership of major items of construction equipments named in clause 4.4 B, capital B, small b, Roman 1 of the ITB, or evidence of arrangement of possessing them, or on hire, lease, buying as defined therein. So what they basically mean is, I have to show the ownership of major items of construction equipments. So therefore, what they intend to say is that in the items of those construction equipments, there has been some shortfall. I have not been able to meet some requirements. Now this ITB is there, appendix is there, that all the entire list of equipments are given. Trucks, strippers, and all those things, machines are there. So this is one ground that I have failed to meet the requirement of the construction equipments. The number 2 ground that they have taken, Lordship will again come to page 121, 4.4b, capital B, small b, Roman 2. This, I'll not trouble your Lordship, but this pertains to key personnels. There has to be engineers, assistants, and all those people have to be there. So it deals with that key personnels. So the number 1 ground that they are saying is equipments, construction equipments, there is some shortfall, and number 2 is the personnels. I do not have the required staff. So these are the 2 grounds. They cannot go beyond this. Now, if your Lordship will take up the affidavit. Affidavit of the RWD department. Is the affidavit on record, your Lordship? Signed by one Pugi Potom. He is the Undersecretary, Rural Works Department. Who's got that? He is respondent number 124, Lordship. The concerned department. One Pugi Potom. If a Lordship will therefore now come to paragraph 7. Paragraph 7, the concerned portion is at page 144, the next page. I'm just reading that paragraph. That the answering respondent state that under clause 4.2.d, that is the clause regarding construction equipment, page 35 of the writ petition, a bidder is required to provide qualification information. However, the bidder furnished the details of monetary value of civil works undertaken for only 2 years instead of 5 years. If a Lordship will now come to page 36 and see the clause, this clause is regarding construction equipments. And what on affidavit is he stating? He is stating that this clause is regarding qualification information. He even refers to the page 35 of the writ petition where this clause is. So a bare reading of the clause would indicate that this affidavit is a bogus affidavit. He doesn't know what he is writing. He says that it has to provide qualification information. And then he proceeds to say what? However, the petitioner furnished the details of monetary value of civil works undertaken for only 2 works instead of 5 years. Now, from where did he get this ground? The Technical Bid Evaluation Committee submits its report and says that I do not meet 2 particular clauses which are very specific, construction equipments and key personnels. Now on affidavit, the Undersecretary is saying, referring to the same clause, but he says that this clause is for qualification information and I fail to meet some civil works monetary value that I'm supposed to give for 5 years and I gave for 2 years. I could understand misquoting of a clause, but this is not a case of misquoting of a clause. He proceeds to give a justification by saying 4.2.d is for qualification information, and I have failed to give monetary value of civil works for 5 years and I've given for 2 years. But this is not a ground in their affidavit or in their technical evaluation. So is everything fair? Is everything transparent? Are they actually know why they are doing this and for what reasons I have been rejected? So probably they are supposed to answer to this, and they have not given any supporting evidence to support or to back this particular statement. So first of all, it is not prudent, it is not permissible to go beyond their stand as is available in their records. And secondly, even they don't back this by any way of evidence. So therefore, on the next date, though I am filing my reply on the affidavit, on the next date, let the records be called for and let them categorically answer to this honorable court as to how they have taken a duplicate stand now. So if this may be observed in the today's order, because otherwise the private respondent is there is no stay order. He is going ahead with the construction, and tomorrow there will be definitely a submission coming from his side that almost the work is over. So yes, I understand these are projects, these are development projects, it has to be done. But at the same time, a petitioner who is referral lawsuits cannot be also left high and dry. If I have been able to make out the case, at least I am entitled to some relief from this honorable court. I'm not asking for. So let them explain this.
My lord, before coming to marry the case, whether this petition, the petitioner who has approached this court, whether he is the bona fide person or not, whether the person who represent the firm, whether he have authority to file this writ petition or not. That part we are raising the issues before
In
coming.
paragraph of the affidavit? This is not a ground in their affidavit. He is going.
Yeah.
And it is very clear.
That part we have to take. That part, if he come up with the
just to save
reply,
the
the
time, I'm saying.
We'll get instruction whether that is done.
How can they
That
take
now
a
I
stand like
cannot.
this in affidavit? Then there is a doubt in the entire proceedings of how they have handled this entire tender process. So therefore, because otherwise there is no stay order. So therefore, I also pray for a status quo, but I know it may not be coming from your lordship.
Tender process
yes,
already
yes. So that
finalized in the month of August. Now he approached before this by
no, this is the third time or the fourth hearing now going on.
after more than
So
a
therefore,
2
I
months.
understand the problem everywhere. But then yes, case should not be dragged to such. Therefore, I'm praying. Let on the next date, lordship will kindly observe this, and the next day they should give a reply regarding this aspect also.
1 to 4.
5. Yes, ma'am.
Item number 24 also, same party, an identical stand they have taken. And identical stand they have taken. The rejection was also identical ground and the affidavit is also identical. And item number 25, I'll be filing my reply. That is okay. I'll file my reply. No, I'm going to file. I'm going to file my reply. But there I am asking for your lordships to give that observation that stand has been taken, and so that is limited to 20 and 24. Yes, sir, my lordship. .2.d. 4.4. Well, yes, and the other is 4.4, capital B, small b, Roman 2. Paragraph 7. By referring to the same clause of 4.2.d. 4.2.d also. Yes.
No question.
On 25th of November also. 25th of November. In the meantime, I will file. Let the matter be fixed.
25th. My lord,
Of November.
25th, my lord, I have some difficulty, my lord.
25th. I've been out session lawyer this
November.
Can it be on 26th then?
No.
Next day, 26th?
My lord, 25, otherwise it's a holiday also.
Is it?
26, 27.
No, it's not a holiday.
Can it be on, my lord? It's a holiday. Holiday, my lord. Can it be in, my lord, first week of December, my lord?
The
This
difficulty
week,
is
otherwise on 22, my lord.
22.
21 or 22, my lord.
20.
Yes.
My lord, this, in this.
No, last month of November, any date, Lordship. If not, 25th is a holiday. So 26th to 29th, any date, Lordship. Because the work is going on at full speed. That's
My lord, due to some personal difficulty, I will be out of station, my lord. Some medical.
then
Yes,
December,
my lord.
December 2nd, Lordship, then.
December 2nd, then.
No, December. Parts I have some program.
Let there be a status quo order, Lordship.
Let it be 5 then. December.
Let there be a status quo order. Any date will come then.
No, we are asking for 22 November.
No, 20,
Let it be 20.
on 21 November, then, Lordship.
Yeah.
21 November.
21.
21 November, Lordship. 22, I'll be out of station. Yes, Lordship, I will file it. We'll file that. Let them produce the records, Lordship, on that day. Let the records be also there. Because if a hearing takes place, maybe we have to look into the records.
It's already there, I think. No. Original मिलेगा ना?
Yes, Your Lordship. Oblige, Your Lordship.
Yeah, Ladyship, we can see that already. Ladyship, may I request items 42, 43, 44, which were fixed for today? Yeah, they may be fixed for hearing on either 18th or 26th of this month. Yeah, and this will take some time. These are connected matter. It will take some time. So yeah, they should be final hearing actually. So you can put it on Wednesday. So Tuesday is 26th. Yes. That's fixed, your leadership. And it can be high up on the board, your ladyship, because. Yeah. Right. Much obliged, your ladyship. Right. Much obliged, your ladyship. Right, and then I'll remind them. Much obliged.
My lord, this others,
Yes, Your ladyship, I have been coming for a few years. In fact, twice I have completed my arguments and then the matter was released. So, because it's a slightly lengthy matter, it's much obliged.
private respondents are there, I think.
Much obliged.
My lord, this item number 33 to 36, other column, my lord. My lord, here almost pleadings are completed, except subsequent development. Just a minute. Now, my lord, problem is, my lord, there is an interim order operating against us. It's a tender matter, my lord. Although process is completed, but we are not able to award the contract because there's a restriction from this court, my lord. So this problem is there, my lord. So early date may be given, my lord. So next week, any date, my lord, 11 to 14, subject to other side, my lord.
11 to 14, I'll have some difficulty. In fact, today I had come prepared for this, but paucity of the time does not permit. My lord, otherwise, if it can be fixed on 18th, my lord, 18th is also a Monday, my lord. On the next week, my lord, I am badly tied up at the principal seat. That's why. And we have only 4 dates next week because 11, 12, 13, and 15th is a holiday. So that is the difficulty.
Then
It's only about a week. 4 days accommodation I am otherwise seeking.
no, it's only of 4 weeks, but only the
4
my lord,
days. 4 days.
4 days.
Not week. But I am appearing in items
No, no, if you
number 33, 34,
today's report,
and 36.
almost 2 weeks. So you are taking adjournment almost for 2 weeks.
No, I am not taking adjournment. The time does not permit.
All right.
tonight.
Correct. Well, I can understand that, but
I am
only
not
my
asking
lord,
that.
probably. So my the other side should also understand, my lord, I'm not asking for this week. Next week, my lord, yes. So that's why, my lord, from 14 to. Then why not this week, my lord?
No, otherwise,
Friday, my lord, or
otherwise also,
Thursday,
my lord,
any date, my lord.
in one of the matters, my lord, Mr. GN Sahavala is appearing. In
Number
that is
35, my lord.
that 35. He will also have to come. So that is another aspect of the matter, my lord. We should.
No, no, my lord.
We should.
Whoever may cast, my lord, only problem is with us, my lord. The tender process is complete. Only, my lord, we are not able to award the contract because there is an interim order operating against us. Not to, my lord, award the contract. Now. That is the problem, my lord. Otherwise, my lord, I can understand.
It is a Monday, my lord. I don't think that will be problematic. Only thing is that I am asking for
Only
1
thing,
week.
my lord, there is a pressure from the department, my lord. My lord. My lord, then you lordship may kindly clarify, my lord, no more adjournment, my lord. Let
No,
it
nobody is seeking adjournment. Your lordship may check the dates. I have never sought for an adjournment, my lord. If the court's time does not permit, my lord, we cannot help it. Your lordship may indicate that first of all, my lord, the matter should come in the admission column because it has been wrongly listed in orders.
column.
Your lordship may indicate that the paucity of time does not permit the matter to be taken up. So it may be listed for admission column on 18th.
And also, my lord, endeavors shall be made for disposal of the
Yes,
matter,
yes,
my lord.
yes. List on 18 and interim orders shall continue till.
Till there is that
That is
absolutely,
affecting.
absolutely.
Yes.
Admission column, my lord. My lord.
Naam de dega abhi.
Please, my lord, this item 27 and 28 I had mentioned this morning also, my lord. My lord, let it come for motion tomorrow then. 28, my lord. 27 and 28, my lord. This item 27 and 28 is an offshoot of 27, my lord. And in 28, my lord, till that, my lord, notice has not been issued, my lord. This was listed for the first time, but wrongly listed in admission, my lord. Let it come up for, yes, my lord. 27 and 28, 28, my lord. Yes, ma'am. Well, it's a connected matter, so let both this item be listed tomorrow for, yes, motion column, 27 and 28, ma'am. Because, my lord, this is an eviction matter, my lord. In fact, I had made a mention on 28th of October, my lord. But this court was not inclined, my lord. So this date was given on 4th, my lord. So today again it has been. Yes, my lord. Let them both come for motion, my lord. Motion, my lord. Obliged, ma'am.
May, Your Honor. So, Your Honor, I would like to mention for the item number 26, Your Honor. So in this case, Your Honor, advertisement was issued on 2020 and the selection process was completed on 2021, Your Honor. But since the petitioner, they are not issuing appointment order, Your Honor. And because of Your Honor, early date may be given because it's been about to more than about to 3 years, Your Honor. Issuing appointment order is still pending, Your Honor. Obliged, Your Honor.
Lordship, item number 41. The record was called for last occasion.
Lordship, we have received the instructions, Your Lordship. We will file our affidavit. Instructions we have received, we will file our affidavit, Your Lordship. Yes, Your Honor.
This interim in. Yes. But matter may be fixed after 3 weeks if
Lordship, Lordship.
much of it.
Yeah, they already filed कर चुका है.